location.
Okay, are we unmuted? Good morning, everybody, and welcome. Can you hear us online okay?
Yes.
Yes,
Yes,
sir.
we can.
Perfect.
Good morning.
A little bit here. Well, we're glad to be back from the holidays, and I always say the holidays seem to be more hectic than the work week, so it's kind of nice to have a break to get back to work here. It's been an exciting period. It seems like the market's off to a great start. It's at least with the calls coming in and the feedback, the market seems to be picking up, which is nice. But like always, we'll start with introductions. Going around the table, I'm John George, on the co-chair on the attorney side at the Broker Lawyer Committee.
S.J. Swanson, I'm a lawyer from Houston.
Mary Miner, broker from Austin.
Ron Walker on the broker side.
Abby Lee, track staff.
Melissa Burgess, track staff. Waitress, all attorney side.
And then online, we had some concern about the weather today. So we have a few attending online fortunately, the weather doesn't seem to be too bad, at least in this area, but I know in Dallas it's being hit pretty hard. But online, if you can introduce yourself.
Christy Tatum Jansen, broker member.
Diane McCoy, Houston, broker member.
Amy Slusher Lufkin, I'm a attorney member.
Melissa Haley, broker member.
Tony Malley, lawyer member, Beaumont.
Brian Watts, attorney, Dallas.
And I know online we have Renee Harvey Lowe's, one of our commissioners who is our liaison. So thank you
Yes,
for
good morning.
attending again today. We appreciate that. And we have several guests around the room as well. If we can start with Mr. Sledge here.
I'm Brian Sledge. I'm a water lawyer with the Sledge Law Group here in Austin.
I'm Tracy Shores, broker.
Sue Crawford, broker.
Andy Cook, broker.
Robin Harris with Texas Realtors.
Erica George, broker.
Chelsea Buckholz, executive director for Trek. I'm sorry about the noise. There's construction going on that was not planned.
Yeah.
But we can't close the door. That's the hard thing. So if we just get super desperate, maybe we crack the door, but we have to be open to the public.
Okay.
So we're gonna just see what we can do on that. If you see someone walking by whistling, you can just shush them quietly and politely.
We try to make these meetings interesting as possible. So it's not about periods and commas only. So
John, I feel like Abby and I just did something very weird, and we do need to tell everybody here, which is that there's been a shift in our positions, which is that
I should say this.
well, sure, you'll do like a much better job because I'm gonna be weird. I've already been weird about it. So
that's actually the next announcement that I had here. No, go for it. I was going
somebody
to.
do it.
There's a big congratulations in order here. So if you want to go ahead and make the announcement.
Well, Tony Slagle departed from the agency in the summer. He was our deputy executive director. That left an opening that led to some shifting that I'm delighted about. So Vanessa Burgess is now our deputy executive director. Yay. It means she can shift all legal questions to Abby, who is now our general counsel. I'm sorry, Abby. We're also hiring for an assistant general counsel that's posted now. So we're still kind of in the juggle mode of everyone doing what needs doing. And I think it'll take us about a cycle. We're on a quarterly cycle of committee meetings, commission meetings, recovering from those things, and then starting again. And it'll take us about a cycle or two of that to kind of settle in. But
Awesome.
I'm excited about these two.
Very excited. It's been great working with y'all, and now new capacities going to be awesome. And for everybody that's attending online, that's an attorney that's interested in the role. It sounds like just post it now. So you already are taking a leap above others by attending this. So encourage you to apply there. This meeting, we normally don't have a meeting, I think, in January of legislative years. And so this is a unique time that we spent so much time on compensation and discussing comp and in the language of it that we had a lot of built up items we wanted to get a jump start on by having this meeting today. And so we know there's a lot of confusion and questions about the language in our Trek contracts. And even more with the interaction with the Texas Realtor forms, which Texas Realtors is not TREC. And we'll get into that today. But we're also going to discuss water disclosure issues and a lot of non-compensation stuff, so we can get a jump start for our next meeting after the legislative session. Our next meeting will be at the end. Normally during the legislative session, the new laws are made that we have to incorporate into our contracts. And so we'll address that at the next one and kind of get a preview of those potential bills that are coming forth during today's meeting, at least.
And Mr. Chair, can you clarify, we are not intending to take action today. We're just jumping ahead. Well, maybe with some exceptions, but major changes to the contract, we're saving those up.
So
true?
it generally true. I think that there are some items we may take action today. I think on the compensation issue specifically, these contracts are brand new, right? And today we have a lot of comments that go into the common questions on how they interact between paragraph 12 and page 10 and the association forms that are out there from Texas Realtors and others. And I think we'll get into that today. But as far as action, if we want to look forward, I'm not sure there's going to be action taken on the specific language, but it's all open, right? This is going to be a discussion, and we can talk through those and potentially propose some things. But the intent when we had this language is to see how it works. And we understand there's a learning curve in that this can be confusing until we dive into it a little bit more. And we're open to addressing any issues that arise and continue in the market. I think we're in the beginning stage of education right now still, but I will have a full discussion on that later today when we get into the comments.
Thank you.
And so I guess I officially called the meeting to order earlier. If not, I do now. And we'll start first with public comment on non-agenda items. I didn't see the sign-in sheet if anybody had any comments listed or wanted to speak on non-agenda items. Okay, hearing none, we'll move forward. And Ron, on here, do we want to jump before the Sunset Advisory Commission on the disclosure issue?
I know that Brian's got some issues, so what I'd like to do is to impose and just sort of take up that issue, lay this issue out for while Brian's here before he has to leave, and then be able to discuss it as we need to after that.
Great. So I'll hand the floor over to Mr. Walker.
Okay. I'm going to just introduce Brian Sledge. Most of you met Brian when he was here a few months ago, and he laid out some concerns related to information about, I'm going to call it just generally water issues. So as part of that, or after that discussion, Brian approached John and I, and then I met separately with Brian and learned a lot. So what I'm going to ask Brian to do is to speak about the need for this, because I was not fully aware, even after his initial presentation to us, of the real need for this kind of information to pass. And I think it's really critical information that needs to be passed, but we can discuss that need further as we go. So what was in the materials is Brian, I asked Brian to put together what he would want to see in the contract forms. And then he brought that over, spent a lot of time with me explaining the need for it, which was very educational. And then I took what he did and came up with something that sort of molded it better in terms of how it might appear in our forms. And so that's what we have in the material at this point. So,
and we're discussing potential water disclosures, additional water disclosures about surface water, groundwater, and other items. This has been on past agendas. It's on this one as well when we're looking into all disclosures. But here, what we're discussing is specifically water disclosures in the contract or outside the contract as well.
Right. So after I sent that draft, or after I developed that draft in my initial conversation with Brian, I sent it back to Brian, and then here in the first few days of January, he sent back some corrections. So not in your materials, but separately on your desk here on the table as well. I don't know.
We are working on emailing those right now to those that are online.
Or corrections that Brian has. So I wanted to use his as the draft. I would say the current draft right now. as you can see, he's highlighted where the changes occur in the draft that I took and modified for his. So
If you're online, real quick, sorry to interrupt, we're on agenda item 3, and in the materials, it starts on page 541. Page 5 of 41, and the specific disclosures we're discussing start on page 6.
So you have 3 forms in front of you. Probably the most important to look at initially is the disclosure form. So it's a 2-page form about information that would pass from seller to buyer. It talks about the groundwater issues, the districts, the water wells, and those kinds of things. Good information that would pass. And Brian's going to hopefully explain for us again the need for this and why it's so important to do it. The other one was in paragraph 7. I took the liberty of adding paragraph 7K as a draft here to see how it might appear following the format that we use for the seller's disclosure notes. So that's the second piece, is how that would appear and how it would be triggered in the contract form. And then because our title notices under paragraph 6 have become a little bit lengthy and I think unwieldy, I took the liberty of trying to say, well, why don't we categorize those between title notices, water notices, and other types of notices here that might be important. So that's the third version. Okay, so that's where we came up with. Those are just, again, drafts that we've, Brian and I have played with to point. So let me turn it over to Brian, and Brian's going to lay out the need for us and the other comments that he has here.
Floor is yours.
Come up here, Brian.
Oh, I appreciate y'all having me. I think it was last January I was here when this all started. I want to thank Ron in particular. You know, I don't even pretend to be a real estate lawyer, although water rights is kind of a specific little subset of that. I've been doing water law and water rights for about 30 years now, and the problems we're seeing on these issues are just getting worse and worse and worse. And most of my clients are groundwater conservation districts, which regulate the drilling and operation of water wells, that you may know, like Barton Springs, Edwards Aquifer Conservation District, for example. The subsidence districts in Houston, and big retail water suppliers, cities, MUDs, special districts, and big river authorities like LCRA and San Antonio River Authority and others that are wholesale providers largely of water. This issue started for us about 4 years ago when Charles Porter, who had been, I guess he works largely on the farm and ranch contract, and we do see problems, especially with the cutting off of parcels on ranches and farms, the subdividing of it, the selling off of pieces that oftentimes we get work from because we have to come in behind it to clean up what happened with the water rights, groundwater rights or surface water rights. We've had cases going to the Supreme Court because the real estate transaction wasn't clear. You have 100 different, on the groundwater side, you have 100 different groundwater conservation districts across the state. They all are allowed by the legislature to adopt their own set of rules, which fit them and their circumstances, whether it's a farming, agricultural, irrigation economy, a ranching economy, suburban settings, urban settings. And so they're all over the board. And so what you do on any piece of land with respect to dividing it up or selling it or severing the groundwater rights or leasing groundwater rights or cutting off a parcel, hoping that the purchaser is going to or assuming that they can drill their own water well to provide water if they're somewhere where there's not a public water system available. Whether you can or not, there's 100 different answers across the state, depending on which of these districts you're in. And you may subdivide a property that, for example, leaves a water well too close to a property line that didn't exist before the subdivision. And under the groundwater district's rules, there's minimum and sometimes under Texas Department of Licensing and Regulation, water well drillers requirements, the water well is now too close to the property line and it has to be plugged. And maybe there's not another space available to get water to the property. Or in the Metroplex area, I represent a lot of the districts up surrounding the Metroplex. Most of those groundwater districts up there have minimum tract sizes and they change. But for example, you have to have at least 2 acres to drill a water well in most of those districts. The counties have their own requirements, but those are mostly septic based. But all the time we get property owners who, are making their life purchase to build their little ranchette out in the country and they purchase a 1.5 acre tract and we have to tell them, you can't have a water well. And there's, while they might be in some public water systems certificated service area for retail water provision, they can't actually get it there. And this is being exacerbated by recent legislative changes. As you know, the legislature is not a big fan of local governments these days, especially cities. And we had some bills last session that passed that really are challenging for cities to plan for their future expansion. They can't do forced annexation anymore after 2017 with Senate Bill 6. And now you can petition to get out of the ETJ. So cities are all across the state pulling back their CCNs, their retail water certificated service areas at the PUC. They're abandoning them because they're saying, look, water infrastructure, wastewater infrastructure is difficult and difficult to plan for. You got to look way out ahead. And we don't know who's going to be in our ETJ or in the future boundaries of the city next week, next month, next year. We can't do infrastructure planning anymore. So what we're seeing is in urban and suburban areas now, it's really happening. If Senator Betancourt's committee had hearings on this in the fall with lots of complaints by builders and developers in Dallas, we're seeing lots of developments go in, all wanting to rely on groundwater because developers, builders do not have the wherewithal like a city to go develop a public water system. Typically, it takes planning. If there is a wholesale provider, you're going to have to create some kind of governmental entity or investor-owned utility to run a water system. But mostly we're just saying that there's not water there. They certainly don't have the wherewithal to do things like our big cities and river authorities historically have done to go build reservoirs in East Texas and billion-dollar pipelines to bring water in. So they want to punch holes in the ground. And they're finding out that, there's these things called groundwater districts and they can't punch a hole. And so the biggest thing that we see is folks outside of the rural setting, and I can cover the surface water rights and groundwater rights in the rural setting as well, but it's really in suburban and urban settings now. We're just, I'm dealing with a situation right now where development went in and one of these 2 acre minimum tract size jurisdictions, all the lots were about 1.8 acres. And they were counting on the streets when they first planned it out, the groundwater rights on the streets, but those weren't conveyed. And it's just these nightmares for landowners. It's nightmares to clean up after the fact. And if they had just had some educated discussions when they conducted the real estate transaction, you could have gotten at this. Or we see grandma carving off an acre for grandson on her place out in the country. And, he can't get a water well on that place. Or we see deals between neighbors where we were best buddies historically as neighbors, and we share a joint water well with just a handshake deal. And now you sell it to, this person moving in from California, and they say, nah, we're not sharing with you. We don't like you, and we're cutting off the water property line. We're putting And these people have now purchased a home on a property and they can't get water to it. It's not as big of an issue, near as big of an issue if there's public water available. But again, increasingly public water is not going to be available, especially in new developments. We also have, something that's really taken off in my career in the last 20 years is treating the groundwater estate and the bundle of sticks that make property rights, which is treated just now it's part of the surface estate, but it's treating it like mineral estate now. It's carving off groundwater rights. It's reserving groundwater rights when I sell a property. It's leasing my groundwater rights because I got into one of these pickles and I didn't have 2 acres. Again, and that varies around the state what that is. I didn't have 2 acres, and so I convinced my buddy, my neighbor, who has 3 acres, to lease me 1 acre of his groundwater rights because I could take 2 acres of groundwater rights to the groundwater district to get a water well. And these agreements are in place, and but these transactions happen, and it's just disastrous for a lot of purchasers. In the rural setting, on the larger tracts of land, it might affect whether you can continue the activities that were on the land, whether it's agricultural irrigation or farming. On the surface water side, surface water rights are administered by TCEQ, completely separate body of law from groundwater law. The water's owned by the state, but the right to use the water, which has been granted by the state historically, through the adjudication process, which was the old Water Commission combined with the district courts, or by permits to the TCEQ, give you a right to use water. And to use it might mean to dam up a creek on the property, might mean to dam up a creek or not, and divert water from the water course, or to use it on your property. And you'll have and so that's a usufructuary right, the right to use. It's a real property right, protected. But a lot of folks now that land has changed from, in many areas, irrigation to, deer hunting ranches. You have transactions selling off part of the property, and there's no discussion of what water rights go with the property. You'll see these old surface water rights typically will say something like, Brian Sledge has the right to pull out 1,000 acre feet of water per year from this spot on this bank of the Colorado River to irrigate 800 acres out of a 1,200 acre tract here in Burnett County. And so I carve, and it's not specified which acres are the acres that are the 800 out of 1,000. In the surface water right. And so unless you make a conscious effort to say, here's how we're going to address the surface water right in the real estate transaction, if you sell off, a part of that property, subdivide that property, it just becomes a nightmare. And we've seen some big cases on fact scenarios just like that have gone up to the Supreme Court in the last decade. So again, so we started when Charles Porter gave this to us, and he was thinking in a farm and ranch contract. He came to the Texas Water Association, which I'm a board member of, and the Texas Alliance of Groundwater Districts. And this is our main 2 trade associations for river authorities and cities and groundwater districts, and said, can y'all help me with this? And we kind of took it in a different direction because, again, the farm and ranch is important, but it's really the suburban settings that are becoming the bigger unimproved lots, residential cells. And so we came and brought the rather obtuse document that we came with last January. Ron, who turns out to be a brilliant drafter and thinker, transmogrified it into this single notice. We had brought you a surface water and a groundwater separately. And into the 6G and 7 and reorganizing 7K. And I think it works. I apologize for not getting my changes to him sooner over the holidays. Just got busy with other stuff, but made a few tweaks here to try to simplify it a little bit so that agents could I think, have a better time understanding it. But our big desire is, and the key problem I had with what Ron sent, which was patterned after what other paragraph was it?
Or seller disclosure.
Yeah.
7B.
7B. It is the option that this isn't required, so we're not doing anything. Unlike 7B, there's nothing in the legislation that says when it is or is not required. And so if we don't want to require it always, and I'm not saying we would need to, you mentioned the condo contract, you know, that I would think we would want to identify situations, and I don't have the answers to that yet, situations when it is or is not required. And maybe the situation is if you don't have a water well, you don't have any surface water rights, and you're already receiving water at the property from a public water system, maybe it's not required. You know, your typical residential sale or business property sale in a suburban or urban area. There's not much danger if you're already receiving public water from the city of Austin or Wells Branch Municipal Utility District or whoever, that you're going to get cut off. But and there's not much chance that, you know, while we do have a lot of folks in Austin who I guess have drilled water wells in their backyards to irrigate their grass, you know, that there's no tragedy there if something happened where the purchaser could no longer operate a water well or can't drill one. They still got water in the property. They at least got water for their homes.
Unless it's another person who's all about, I don't want to just say greenie straight out, but all about their green garden.
Oh, yeah.
So that may be a selling feature. That's a question I had too, is how are we mandating? How are we going to mandate this?
Well, and that is a great summary, and we can appreciate that, I think, on many different levels. And for those watching that may not deal with water rights a lot, may deal with just residential sales in neighborhoods, this highlights the complexity of what this committee is faced with in terms of bringing what is a serious issue that impacts not just these larger transactions like we'd like to discount sometimes in terms of, well, they're just going to draft their own contracts. This is an issue that clearly goes beyond that to impact small lot sales, impact residential sales. And we're challenged with how do we get that in a understandable, brief way that then can go into the contracts or be an option to protect the consumer, as we're challenged and charged with on this committee. And so it's not an easy task. And it clearly is a complex issue. And this draft that's in the materials and the updated draft here is a great first stab to show what could be done. And layered upon the issues that are here is typically we as a committee and in TREC have not gone beyond the statutory required disclosures. Yep. And so our seller's disclosure notice, it follows the statute 5.008 of the Texas Property Code. And a lot of people use the association forms to go beyond that. But we as a committee haven't ventured into requiring other disclosures outside of the contract with Farm and Ranch, Vacant Home, and New Home that have a few seller's disclosures in there.
Well, and even moreover, we have just barely, I mean, we don't even offer it, mandatory or not.
And as part of the same
now.
agenda item, I believe we have a sunset report to review that also requests other disclosures. And this is a big one. And I really appreciate, Brian, your providing of this information and going through, because I think it clicked after our talk with Ron, after his discussions with you, it clicked for the first time with me on how big of an issue this is. And even with the past presentations and stuff, it was done in a way this time to really crystallize that this is something we need to seriously look into. I think looking at this and the other disclosures that are requested, we do have the disclosure working committee or subcommittee that is on here that I would like to go around today to get all the questions asked by any of the committee members that have any, since we have Mr. Sledge here to answer any of those. I do think this is something we need to take a serious look at, including in the contract, whether it's in paragraph 7 that's drafted here as a subpart, whether it's this whole disclosure. The point's well taken about requiring it or not, and that's where we in my view, that discussion is required with A, B, C, and D. It could complicate and confuse as well. So we had to educate the consumers that use these contracts across the board to then understand. And that's going to be a challenge on how we get that threshold, I think, to say this is the situation it's required, or give enough information so the sellers know, right? That it taken so much for us to appreciate the issue. Having somebody that's not involved in periods and commas, having to use it is going to be a challenge, but one that we need to undertake trying to do, I think. So what I would like to do, Ron, if you're okay with it, is to let anybody ask questions around the room.
Absolutely.
And then at the end, this is a great draft that I would like to then come back and try to, in July or the June or July meeting, have something that we can look at with other potential changes that we need to make, proposing at that time to go in, if that's okay with you. And SJ, Farm Ranch, do you have questions you'd like to?
I do. I mean, I will say from a person who works a lot with the Farm and Ranch, and I'm sure my colleagues that do that would agree that this is an issue that comes up all the time, and it's coming up more and more. Just to state the obvious, there's not any more land being made. So, what's out there, a lot of the larger ranches, I'm going to say, unfortunately, are not staying larger ranches, and they're being broken up, and sometimes it's developer, or sometimes it's just smaller pieces. And so I think this will continue to become a larger and larger issue. And it is so confusing because there's so many different regulators or no regulators in certain places. So I applaud this, and I thank you too, Brian, for putting it together. I do feel a tsunami of what is this? Why are we having to do this, from a bunch of licensees who don't deal with this. And sometimes that may just be the way it has to be. But I like this generally. I just have a couple little comments that we may need if we are to do this and change our rule about what do we promulgate. And I'm still noodling on the Sunset Commission. Is that really part of the ledge? I don't know. Not really. Yes, no. But we ought to make this form look a lot like our others, which it mostly does. But, add at the top, put the property, make sure all of our language is similar to other language. But really, I think it's really a good effort. And I think it's pretty self-contained. It contains enough education in it, I think, for certainly the ranch brokers that I deal with on the level that they are on. They are, very sophisticated, and there are usually lawyers involved. So not always, but usually. So I'm going to reserve time for later, maybe after I hear everybody else. But I think this could be good, and I can see myself voting for this, adding this to our rules about promulgating.
And I do have you on the subcommittee for disclosure. So I have SJ, Melissa, Diane, and Ron as being the four that are on that subcommittee. So it'd be good to have your voice, especially with the farm and ranch side on that. Mary?
I like it. I think it's more educational for even people that think they want to do farm and ranch or want to go out and sell that one lot.
Yeah.
And don't understand that the lot's for sale, but there's no water. So I think a lot of it is a good education piece and explaining it. And I think we need to cover it. I mean, I'm not real versed on what we promulgate and what we don't, but I think it's definitely, even residential agents have got a lot to sell. Do they know the education on selling that lot? I mean, I guess the first question is there public water there, or if there's not, or if it's 2 acres, or if it's only 1.7, or, that type of thing. So I think it's something that, because we are finding those lots in different little pockets.
But Mary, just to clarify, some of us know, but historically, this committee has not created or added a mandatory disclosure unless the legislature has passed a law that says we have to do it. So we have not done any of our own fabulous drafting. I think we did add in, we created the flood zone for leased properties because that was a legislative.
Yeah, the only thing that we have in the contract that's not legislatively mandated is the general disclosures that are in the farm and ranch
Right.
and in the vacant lot, new home as well.
Right.
You know, previous flooding, all those kinds of.
Yeah, and those have been an exception, but as far as a disclosure notice, standalone and our disclosure notice, we've only moved when when the legislature has changed the law. So this would be different. Well,
And that's a tough one because where's the line drawn? If we
Right.
look at historically, there's so much that we think, could be a benefit or maybe not. How many transactions does it impact or not? And so that's why we've had that kind of that line there of the legislature gives us direction on what they intend to require in these contracts. And then there's associations and other forms out there that if more protections wanted by a buyer or seller, they can add those, mostly sellers and disclosures here. But that's kind of the history there. Next.
I can see promulgation in farm and ranch because I think that's probably where the bulk of the transactions are going to see it. I think in a residential context, it's going to create a ton of confusion for agents and brokers that almost always use the 1 to 4 family or condo. And the question, how do I figure out if it applies? What do I do with it? How do I explain it to my customer? But in farm and ranch, I think it's enough to at least, raise a hand to say, if you don't understand the transaction that you're getting into, you need to go to your broker and get more help with it.
and or the land, the unimproved. Because those are likely.
Like what he said, mom breaks off her 2-acre lot and goes to sell one. And a regular agent will just go, okay, I'll just sell a lot. And I don't think that we know all the caveat behind it.
And the vacant lot is where, to me, we start bleeding over to that being used by a lot more agents that don't do that farm ranch
Absolutely.
larger style one, and then introducing that potential confusion.
Absolutely.
On that. We go online. Diane, if you want to.
Yeah, thank you. I keyed on what SJ said about that this is an issue that comes up repeatedly in farm and ranch. And I think one of our committee's duties is to pay attention when there is a recurring issue that comes up. And the work that was done on this water notice, and I know that Legal 2 spent a lot of time on water issues to educate the license holders on this issue across the state. So as we always say, education is the answer. And I think this is a problem, and education will be the answer. And a notice applicable to farm and ranch and any other situation that's out there, there's a need, and I think we should address that need. My question, and thank you certainly to Ron and Mr. Sledge for bringing this forward, because it's something definitely to work on. My question is there any reason why our committee can't address some of those issues that we see are a recurring problem, such as issues that come up with water notice? Is there anything in the TREC rules that say if it's not mandated by the legislature, it's not an action we can't take if we see a need?
There's nothing in our directive or otherwise that would limit us from taking that action. So that's been a more of a policy and where to draw the line that we've had, and clearly we have other disclosures in some of the forms that have been there for a very long time.
I think this is great to add.
There's no limitation on it.
May I?
Sure.
Yeah, and it was my understanding before we came to y'all in the first place that there was two ways to get something in disclosure forms. Start through this committee, I guess with approval from the full commission afterwards, or the legislature. Now, I've been a registered lobbyist for the last quarter century, and I worked at the legislature for a period of time before that. And my opinion and the others in my association was if we can avoid that sausage making process, because this is,
Yeah.
this isn't hot button issues like border security or school vouchers. This is nuanced legal stuff. And if we can keep the legislature out of it, we should keep the legislature out of it. I'll tell you, I got members that I'm trying to avoid, members of the legislature who are wanting to file bills this session, and I bet we see bills this session on this issue. I've heard of at least one local Austin rep, not that has a chance of passing, but that wants to file it. And we had gone to the Sunset Commission, just back to this management recommendation that came out of them and said, no, we're already working with the broker lawyer committee. Well, the House member on Sunset, the House public member, Mr. Austin, came up with this recommendation. I don't know what issues he's dealing with. I think he's in the title or real estate world. They caused him to bring those up, but it wasn't from us. But then Stan Kitzman, Representative Kitzman, who's on my board of the Texas Water Association and has sat through all of our 2 or 3 years of working on these issues, and just got appointed to Sunset. Well, he jumped on that like a perch on a June bug and said, oh yeah, we do need that. So, I mean, we have the Sunset, of course, is the legislative agency and this recommendation. And then, of course, they'll come back to Trek to see if y'all have implemented their management stuff. I've got lots of Big River Authority clients who've been going through this of late, but we're just hoping we can just work it out with the common sense and brains of the folks sitting around this table and keep the ledge out of it if we can.
I wasn't recommending it. I was just.
Yeah,
reporting.
I'm just.
Well, and the one challenge we have is implementing sometimes legislative things that do what we do is that legislating outside of going through the legislature by we're starting to require things that in standard contracts that have mass adoption in many deals. And to the extent we start making requirements, it's almost like we're taking legislative action without going through the representative process there, which is a concern to me as a general level. We also see especially with the water district notice, how confusing that is. And when things are done without a lot of guidance with thinking how it impacts the day-to-day consumer and in transactions, how confusing that mud notice is. And then not having the ability here on this side to then penalize water districts for not following the law and making it harder than it needs to be. It's a difficult issue. And there's a lot of intersections, I think, there that we have to address. And we have to be careful and mindful of this committee, especially on that legislating from here to mandate things that generally would be across the state. So that's the challenge that we can't delay on looking at this. This is a big issue, but it goes into why it's nuanced and probably best addressed where we're not stuck in a meeting time to do it, to then open it up to the full committee. And then that's kind of what we talked about throwing back. The working group that was there, this compensation issue and others took up so much time. Now we can put this on the front burner to then have it to focus on this time between this meeting and next meeting.
So let me just tell you how I sort of reconciled it, because I was going through this same issue some months ago as well. I reconciled it primarily by looking at what we did with leases. And you have the natural resource leases and those other types of leases. Initially it was, we just need to know, and someone's got to see them, and we don't know how they're going to negotiate them. But if they get them ahead of time, then they negotiate what results from it. So what I see this information being is, let's just get the information there, then let the parties negotiate the terms that we need to follow. Now, we may later, years down the road, develop a form that deals with some of these key issues that need to be negotiated. But right now, I think let's just get the information over to them, kind of like we do with the surface leases and the farm and ranch and those kinds of things that you want to just see up front. That's how I reconciled it. And just said, this is information that needs to go for purposes of negotiation.
And for understanding and clarity, because clearly consumers are in potential harm here, right? If they have, especially these transactions. So that is reducing controversy and protecting the consumer is one of our directives. So
I think it helps raise the awareness that there's diligence that needs to be done before you get all the way into the transaction. I mean, that's really the point.
And so online, Brian, I see your hand up, so you have the floor.
First off, the first comment is this is a wonderful product, And I think it really is going to be something that will be valuable to the people that are affected by groundwater issues. Brian, you probably have come to the realization that everybody on this committee has, and that is when Ron gets involved in working with you on something, he really makes you look good, doesn't he? This is an excellent product. Second of all, in terms of the disclosures, and when you defer to what the legislator's done and when it doesn't, when you don't, I look at it in terms of the legislature enacted Property Code Section 5.008 that provides a format of disclosures to be made that is relevant to 1 to 4 family residences. And since the legislature has occupied that space, we defer to them with respect to 1 to 4 family residential. However, there are things that it does not apply to. It doesn't apply to new residential construction, vacant land, farm and ranch, and that is where this committee has typically gotten involved with providing and discussing specific disclosures that are outside those that were promulgated by the legislature in 5.008. I do have a question for you, Brian, and that is, I see that this would be absolutely relevant to farm and ranch. To what extent do you think that any of this would be of material significance into the 1 to 4 family area as urban sprawl continues and new developments are created and local governments face pressure in how to provide services? Does this bleed over at all into the 1 to 4 family such that we should be considering something in the 1 to 4 family contracts?
I think you absolutely should. And as I noted for Ron, I'm not as familiar with all of your contracts, except for having purchased a few homes and done a 1 to 4 family. But those are the largest sources of our problems right now. I've got my wife, who's my law partner, not a recommendation for the weak at heart. She's got an endless enforcement docket in Harris and Galveston counties of folks that have purchased properties and find themselves somehow or another illegally operating an existing well, or have gone and drilled a well and find that they didn't have the authority to do that. And she does a whole lot of work in that region. It's just it's an endless docket that's feeding, I think, 4 law firms from the Harris Galveston subsidence district right now. And my work's mostly in the Metroplex, Tarrant County, Johnson County. I'll do county seats: Waxahachie, Cleburne, Weatherford, Glen Rose, Decatur, Denton, Sherman, Denison. Those areas around the center of the Metroplex, they're all going in on water wells. Everything's going on water wells, and the little water systems out there, these tiny little towns like, used to be Aledo, towns just outside of the periphery, or Rockwall on the east side of Dallas. They're huge now, and they're growing, and they have no water supplies. They can't satisfy development, and so folks are putting holes in the ground. The other big issue with that I'll promise you're going to see realized in the next decade or two is that water is so grossly undervalued right now. I go into some communities across the state where people still have a $40 water bill, and they are just, it's pitchforks at city council when the average monthly water bill goes up to 50. But you've got districts occurring around the Austin area where the typical monthly water bill is $300 to $500, and
That's probably right.
And that's going to be the rule, not the exception, all across the state in the near future. And what folks want to do when that happens is they want to water the grass with a private water well. And we have, in the Metroplex area, we have about Parker County, for example, Weatherford, has about 1,000 wells being pumped in the ground every year, all for residential. It's just that number is nuts, just for the record. I mean, compared to what we've seen historically. And so all homeowners are becoming water well owners and operators. And virtually none of them understand that they may have reporting obligations, well operation obligations. If the well's not already there when they get it, there's limitations on where you can drill. They, on unimproved, they'll come in and design their house, which is usually, somewhere near the middle of the lot with a driveway coming in. Turns out that middle of that 2-acre lot, if you're complying with the district's spacing from property line regulations, is the only place you could have put the water well. And so now they're in a pickle, and it wasn't disclosed by the seller, and it wasn't disclosed by the agents involved. We're seeing lawsuits between buyers and sellers just going up exponentially. I don't know the degree to which brokers and realtors are getting pulled into those yet, but they're gonna. And so, but in all of it, if you just had some simple discussions and went through, these questions that Ron and I put together, again, 99% of them, Brian, it's I'm buying my house in Allendale. The city of Austin supplies my water supply. I don't need a water well. I don't want a water well. And all these issues are totally irrelevant. And I think you could, I don't know what the numbers are, but for existing properties today, most of which outside of farm and ranch, talking about urban, suburban development, 99% of existing properties, I think probably, or 95 are on public water. None of this is an issue.
Right.
But for the other 5%, which are still hundreds of thousands of properties, and for new developments coming in, again, I represent a bunch of water suppliers. We're shutting down. We've got all we can do to keep the city residents we have right now inside the incorporated city limits supplied with water with the internal growth we're going to have because of the challenges of getting water. And so it's all going in on water wells, and nobody's equipped to deal with it. Nobody knows when I'm in Cleveland, Texas, and I buy a 2-acre lot just outside the city of Cleveland, because Cleveland's one of those who has pulled back its entire CCN. It's not going to provide water outside of it. Grand Prairie, others are doing the same. I don't know that there's a thing called the Prairie Lands Groundwater Conservation District, and that's who governs my water well. But if I had to have a short discussion about it and just have it brought to my attention when I purchase the property, maybe I will. And so, I really think it's mostly a residential issue. But that's not to say, I represent King Ranch, and they're in the business of acquiring properties all over the state for the purpose of their turfgrass operations. And man, just sorting through some of it's like full-time business for a lawyer, sorting through all the sloppy property transactions that happen on farm and ranch, and in discussing exactly how the water rights associated with the property, both surface and groundwater, passed from cell to cell over the years.
If I can jump in with 2 quick questions here. In one, between the 100 districts, it sounds like the rules vary greatly.
They do.
Right. And so we're not dealing with some uniform set with minor changes. What are the requirements on the districts themselves for publication of the actual rules? We have going to the MUD context, the requirement for certain things be posted on the website that aren't always there. But what on this side would allow consumers to then go find the information?
I think all 100 districts have their rules up on their website.
And is that required by statute, or is that just they do?
It's not. It's just a much easier way to distribute them than to have a million Public Information Act requests. Stick them up there. You can print them out yourselves. I've represented 22 of those 100 districts in my in my career. And I mean, and some of them are just, there's some podunk little districts out there that the entire, used to the model until about 2000, the model was outside of some big districts around the Lubbock and Panhandle area. The model was single county groundwater conservation district. They were easy to form, 5 elected board members, 1 countywide, just like the judge, 4, 1 from each of the 4 commissioners precincts. And some of those little districts out there, they're real simple. It's not an issue. In the urban areas and suburban areas of the state now, most of those districts have been created in the last 20 years. They're pretty sophisticated districts. Comparatively, some of those little West Texas districts, they got 1 employee, the general manager, and they get a new well. In the big districts around the Metroplex, you have 2 to 3 to 4 county districts, and around San Antonio, Austin, and Houston, and they have big staffs. They have sophisticated websites with all their rules published and available. Forms.
The reason I ask is to preemptively, and that the subcommittee can look at this, is to address the best we can and how we draft it, the issues that we're seeing with the mud or the water district notice, because that's such a source of frustration right now. If we can draft around it or draft any requirements around taking into account the availability, some that may not have it as easy as others available on the website, or not having a mandated.
I think the Water Development Board has all those rules too. As far as your experience with special districts and this bill from last session, which I know has been a miserable experience for y'all, figuring out if you're in a groundwater conservation district and which one is real easy. You just got to know which county you're in. There's the Water Development Board website. There's 100 websites across the state that have the map of the 100 districts. I think there's only one. Well, I say that out in the Lubbock area, it gets patchy. It's a patchwork out there, out in the country on the farms. But in urban, suburban type settings in the vast majority of the state, you're either, I'm in Cameron County, Texas. Look at the district map. That's Cameron County Groundwater Conservation District or whatever.
And I think we've had that map even in our legal update materials 1 or 2 times ago as well. So that's there. And considering that, it's then being able to go get it, just taking that into account. I'm not saying it's going to be the same, but something to think about. And to move things forward, we can go next to Amy's got her hand up. So we'll go to you next.
Thanks, John. And thanks, Brian, for all of your information. I think to follow up on Brian Watts's question, your statement about it applies to residential, I think, is a different answer than the question of, does this apply? Do we need to apply it in the 1 to 4 family versus is it a disclosure that's given when it's an unimproved property? Because it seemed like your comments are more directed at someone's going to build a house and they may want to build, they need to be aware of this information. But if there's already a residence on the property, are you still seeing issues with that? And the reason I ask is I don't know if that's possibly a way we could delineate between when does this need to be given? Is it just with a farm to ranch, an improved property versus having to include it with all 1 to 4 family? Because when we say 1 to 4 family, we're talking about our contract that is for an existing home. So can you speak to how much of it applies to existing homes where there's already a home there versus a new development where someone's buying a lot and building a home?
Yeah, yes. Again, in the vast majority of those, I don't think it'll be an issue, but it's the exceptions to that statement that are the problems that we encounter. It's shared well agreements. It's, I guess growing up, everybody in this room is somewhat privileged. It's amazing how many situations we come across in existing homes where there are shared wells by a group of neighbor, either two or more neighbors, that in a system that doesn't rise to the level of the definition of a public water system and get pulled into TCQ's regulations for that. And a lot of it is intentional. You know, it's a lot of time it's poorer folks out on the outskirts of town in the country. They have small lots. It's a lot of times it's folks for whom English is a second language that we encounter. They got on here. There's 8 houses on this street. Turns out the water well was, on John's lot, and guess what? John's got pissed off at all of us, and he's cutting it off at his property line, and we're all up creek. It's the example I've come across several situations. The example I said earlier in the meeting where a shared well agreement between just 2 neighbors. Why do we both need to buy a well when we can trust each other and we're good buddies? And this well over here in our area costs $30,000 to drill because the water's a little deep, but we can make good water for you and me. And then guess what? Brian Sledge passes away, or Brian Sledge moves to town and sells it to this jerk, and they don't get along, and he's cut off, and this person's without water. It's situations like that again, I bet they apply to less than 1% of residential properties right now, but one that you would sell on a 1 to 4, but there's still thousands and thousands of them out there. And I'm sensitive to the fact that, the vast majority of realtors and brokers don't want to have to jack with these issues when you don't have to. And maybe there's a way, like we discussed earlier, where you don't have to fill it out if, there's certain things happening. Like, I don't have a water well and I'm on a public water system from the city or the mud district or whoever that's already serving the property. Don't have to bother with any of this. It's when you are relying on your own water well, some water well that's coming from off the property that's not a public water system, or in cases, some surface water diversions that are treated, that you really got to ask these questions before you get yourself in a pickle.
And I ran into that issue in not necessarily water supply for the house, but water supply that's shared for irrigation purposes. They were on public supply, and that being the parties went into it thinking it's just fine. But they wanted to do an oral agreement, and they wanted to, how do we write this up? And then, well, you can't, because the regulations prevented the sharing of the well on that particular size lot. And so it wasn't even permissible, and they didn't have it done properly to begin with. So it can rise in other contexts that aren't necessarily water supply for the existing house, but for other ancillary.
The other thing I'll tell you that I haven't mentioned that we've seen on the rise over the last 10 years, and it's just by creative developers trying to maximize the number of lots they can sell in these areas where new developments are necessarily having to go in on private water wells. And they come up with these, we call them cluster systems. You've seen it in the septic context historically, where you have 2 or 3 homes feeding into a common septic system that's maintained on a lot. But now we're saying it's a way for them to get around some of the tract size limits. They'll put in a central water well. It's serving 4 residential properties. And the water well might be on a separate standalone tract. Sometimes they create some little micro HOA or something that owns the tract with the water well, but they're done by, increasingly we're seeing unsophisticated developers that, there was a rancher or some dude named Bubba yesterday, and now they're a developer. But they come up with these creative ways to get around the rules. And so you're getting lots of these shared wells, oftentimes without any kind of written shared well agreement on who's entitled to what rights you have to continue to get a water supply from this well. And that's, again, we see that both with new construction, and now they've been doing it for the last decade or two. We're seeing a lot of it in sales of existing homes. And the lack of specificity in the original sales and in the supplemental sales are just causing these problems.
Okay. Christy, like you're next on the screen there.
Yes, so all of the situations and scenarios mentioned are real life and are happening. And especially in our area, as Brian was mentioning, Waxahachie, Cleburne, all those areas, which is right smack dab where we are, is we're seeing a ton of larger tracts subdivided, sold off in smaller lots. None of these conversations are occurring, or if they are, it's very rare. And I love, even though we don't typically provide us a disclosure that isn't something that doesn't come from legislature, I do think this is something we have to heavily consider because of consumer protection. And having the conversation, and as was mentioned earlier, being able to have all the information up front to negotiate it. So on the back end, there's not lawsuits, there's not issues, there's not people without water. So I am all in favor of continuing down the path of something of this type in order to have that transparency to the public and the consumers.
Great. Melissa?
I concur with Christy. We're seeing it, and I'm on the opposite side of the Metroplex, but you know, we cover that urban sprawl that's going north, because someday Sherman and Dallas are just going to be one big clump, and everything in between, all of that Denton County stuff, you know, lots and lots of issues with this type of thing. And the other thing is there's some information on here about water courses, and we run into that sometimes too with just, you know, residential where somebody's selling their 2-acre lot and they've got a creek running through it or a creek in the back or whatever. And I think at least having the conversation up front is helpful. So if we had something that I kind of like what Mr. Sledge was saying about, if you're on city water or you're already in a mud district, like this form's not required or this form's not for your use. But if you're not, this is something that we need to have available. So I mean, I'm kind of with Christy. I see it as an issue that needs to be addressed.
Awesome. Tony?
Thank you, John. No, I'll be a little more brief. I'm a big proponent of it. I like the idea across the board as well. I'm not sure that, I mean, I know that we need more education when we put this into play, but you know, with a small brokerage that I manage as a broker, and I'm on this board as a lawyer, and seeing real estate transactions from the outskirts of Fredericksburg to Dallas to Del Rio to Beeville. I mean, I'm seeing 1 to 4 family residential form is not utilized by the agents only inside city limits where there's public water. They use it everywhere on a 50-acre tract. If there's a house on it, a 4-acre tract, grandma carved off for a friend. I think if we just did it for farm and ranch or unimproved, we would leave a hole in where it needs to be disclosed based on the way the sales agents use the forms. So I'm a big fan of putting this through in some manner or another.
All right. I have one follow-up question in the SJ, and then we'll move forward. Who's that? Oh, Darlene. Sorry, Darlene. Sorry. I think we started.
Myself.
There you go.
Thank you. I agree. It could be a good thing just based on what I'm hearing. I haven't had a lot of experience with it personally, but from everything that's been discussed, I agree. It's a good thing.
Right. I think Diane. Oh, Diane's hands up.
Yeah. And the question I had for Mr. Sledge is, in your opinion, do you see this information being in the format of included in each of the contracts as a seller's disclosure notice or as an addendum that would be used when applicable for any of the contracts?
What we tried to do is create it as an addendum that can be used for any contract. And knowing that there's a dearth of water law experts out there, what we've tried to do is just ask some basic questions that are the red flag questions that we think anybody could probably answer with a, do you have a water well? Yes or no? Do you rely on water from another property that's not but not coming from a public water system? Red flag. Because again, they're getting creative. One of the things we've seen a lot of are going back to that last example I just had. They need 2 acres to put in a water well, so they'll come up with 4 half-acre lots. The developer reserves into himself the groundwater rights, or the home builder. I've seen it both ways on that. And they got 1 water well serving 4 properties. And then, this home builder that owned it was an LLC that's now defunct. What can we do with this water well? I'm boring you at this point. I'm sorry. I'm not answering your question. I'm just thinking of all the other stuff.
You did.
Cross on a daily basis, but asking these questions that you could ask in any property transaction, that again, for 99% of the properties you sell, it's none of them are going to apply. And so when I first brought it to y'all last January, we had 1 groundwater form, 1 surface water form. We tried to explain what groundwater was, surface water was, what diffuse surface water is running across the land. Way too complicated. Ron and his capable drafting cut that down to something I think that's pretty manageable, and that most anybody could answer, or with just a little bit of effort to figure out how to answer. And again, I just think it won't apply in many situations, but the percentage of situations to which it will apply is going to increase dramatically in the coming years.
And it's difficult especially when we geek out on certain things like contracts on this committee, the water issues, we see the potential harm and how to address it in a simplistic way. And what you referenced before, the first materials provided were a small little book, right? And then now we developed this to bring it down. And that's the challenge that we have before us, is how to address it in a succinct way that's understandable. And I'll tee it back at the SJ, and I think then we can move on to the other items. The one thing I would just put to the committee is, in the definitions, to the extent these aren't directly out of statute, to be very careful in how we draft that, to make sure that we're not going outside of any law or conflicting law, and just be mindful of that.
Yeah, most of these came from, Brian had these there, and then I checked on him, and they resided in a couple of Supreme Court cases as well. So most of them are very consistent with the language that's used in defining those.
Okay.
Okay, that was my specific question, is where are these definitions from? And we'll talk about that more in the committee meeting. Okay, that's all. Thank you.
Hey, John, I have one more thing. And this is just trying to get some direction for the future on a 1 to 4 family. And Brian, since you said that it may apply in 1 to 4 family transactions, I could see us having a notice in the forms where, if water is provided through a non-public water well, then a seller's disclosure should be attached. The next step would be, okay, so you have one of those situations, you may need to have some sort of agreement between the seller and the buyer as to how to address that. And my question is that something that is susceptible to a simple form that a non-lawyer could use? Or at that point, do you reach something where these things are all over the board and you really have to have something specialized?
It's a disclosure. And it's a disclosure and the contract stays an as-is contract. I mean, that's.
Yeah, well, no, I get it, SJ, but and my question is, would it behoove us to have something else? And is it possible to have something else that would be able to help the typical real estate agent if they are confronted with one of these situations, not just the disclosure, but an agreement of the parties as to how to address these water rights issues?
I think that's phase two.
Yeah, that's
Hell
definitely,
no.
yeah, I think at
Hell
the
no.
end, I'm leaning
No.
towards SJ's sentiment there because of how varied
Okay.
and different in.
Yeah, that was my question. Yeah.
Be so much, but
Oh, that's
but it definitely would be, I think, a phase two after getting the disclosure out there to even entertain, because we have to get the disclosure done first.
And John, I know everybody remembers because we have the seller's disclosure memorized from the property code 5.008, but just a reference that the very last, are you aware, questions in number 9 is any portion of the property located in a groundwater conservation district or subsidence district? So this isn't completely new, and maybe this is a link that would support our, maybe we just add on there, if so.
Almost like in the title notice section, where we
Right.
drafted it to punch up the disclosure
You get a
that's
second.
already made.
Right. So.
Well, Brian, thank you for all your efforts. I know you pushed and have been pushing on this for a while, and I'm glad that Ron was able to pick it up, and your efforts aren't unnoticed, and all the communications you had with me long before that. I'm glad it's moving forward now, and this working group. What I think the intention is for our next meeting to have a draft that can be presented for proposal, or whatever the recommendation is first. But I think we got everybody's collective thoughts today, and then assuming that is some addition to the contract, to come back for the next meeting with something that we can look at potentially proposing with other changes we make. But I really appreciate your efforts on this.
Thank you.
with Mr.
Can I throw
Porter.
on one last thing?
Sure.
Just because I keep thinking of these issues, sir. Regardless of whether it's a water well on a 1 to 4 or a surface water right for a farm, purchasers typically have a legal requirement to notify either the groundwater district of the change in ownership within, it depends, 30, 60, 90 days, depends on the district's rules of selling a property, or to the TCQ on the surface water side, with enforcement and civil penalties if you don't. And I've seen districts put that obligation on the seller, seen districts that put that obligation on the buyer, and I've seen a bunch of enforcement cases against homeowners for failure to notify the district. They didn't know they had to,
And that's contained
easily prevented.
and that's contained in the district regulated rules.
Yeah.
Maybe we just add another, in the little warning section, you may be required to.
Okay.
Anyway, I appreciate
Thank you,
y'all
Brian.
hearing me out. Random thoughts on troubles around the state.
Well,
You betcha.
absolutely. And thanks to Charles Porter as well, that has worked with you and really been pushing this issue for a while as well. And he states it in eloquent ways, just as you do. And I think
He's much
we're all
more
beginning
passionate
to,
about it.
we're starting to
He sucks.
appreciate it more and more on the need to hear, which has brought us to this point. So thank you again.
Thank you
for
all.
that. Let's see, what time is it here? I think we've pushed forward with the, maybe get through quickly the other agenda 3 items and then take a short break. Looking at agenda 3 item, we have a Sunset Commission meeting decision material that you'll see in your material starting on page 2. This is from November 14th. And several proposed recommendations were made by various senators or representatives in these. These are not statutory directives. These are management action recommendations. And I think to tee this up to begin with, that we put this in that same discussion with the disclosure working group, because they all tie into requests for disclosures on various items. What I would like to do for today, similar to what we did, I'll run through what, on a high level, what the requests are. And then if any committee members have any input or stuff they would like to add to either one, for the working group to consider, to do that, with the thought that at our next meeting, if the working group can provide us a further analysis and potential drafts, if they take that step to consider for proposing. On starting on page 4, the actual recommendations, we have Senator Middleton, who would like to see further insurance disclosures in the contract, and whether the property is presently insured, including the different types of insurance, because of an issue that they have seen in terms of some people not being able to insure their property. And I think written in there is a very expensive insurance rates that might be out there. Senator Paxton would like to see additional disclosures related to private roads that may be adjoining the property or on the property, in disclosures related to what I believe be financial aspects of maintaining that road or access to the road. Representative Kitzman and Mr. Austin proposed similar things to what Mr. Sledge just discussed with us today about groundwater issues, and to work with stakeholders with groundwater to add language to the contracts.
I'll just interject one thing right there. They had an amendment during the hearing where they added surface water rights to that recommendation as well, which is addressed in these drafts, but just something to note.
Great, thank you. Mr. Austin would also like to see conservation easements addressed in the seller's disclosure form to inform parties whether property is located within a conservation easement. I believe we have additional materials later. We may get more into that particular comment on conservation easements. And so we'd like to see additional information about that. And then Mr. Austin also requests disclosures related to above ground storage tanks to be added, specifically on information on the existence of above ground storage tanks on the property that are more than 500 gallons and that store petroleum products or other chemicals. And so, and I know we've all looked at these. If there's any thing you'd like to propose for us to discuss or that you'd like to comment on now for the subcommittee to look at, I would open the floor to see.
I would first like to know, and I don't see the chairman on, but I'd like to know if the commission itself has expressed any thoughts, or if the executives have expressed any thoughts about, you know, do we want to have some mission creep? As far as.
What do you mean by mission creep?
Well, the historical, we have not made any seller's disclosure other than that was actually legislatively, you know, an actual statute. So.
I don't have any word from members of our commission. I would suggest that it makes us nervous, that there's a real clean line with following the legislature's wishes. And in fact, we've done the training with this group that we received. Okay, in one of the sunset.
We are completely untrained.
Well, we have been using a video in some training, and the video comes from one of the recent Sunset Commission meetings, where another state agency was going through a sunset review, and Senator Middleton was making recommendations and admonishing that state agency for making decisions in the absence of legislative authority. And in that instance, it was this agency saying, well, the legislature didn't say we couldn't do this. And so we went ahead and did it. And that got them into trouble. And so it was a very public display of the legislature's. And that is extremely instructive to us in terms of making sure we have express authority to do things. I'm going to leave it to Abby to talk about whether or not we have the authority to do that. But I think the clean lines of staying within property code directive on seller's disclosure is pretty simple.
And I'll just add two things to your point. So the Sunset Commission was made aware of BLC policies, process, what the commission's authority is in relation to the committee's authority. And so they were made aware of that. So, you can look at these recommendations with that background. I would also say, especially on some of these seller's disclosure notice recommendations, I think the timing will work out because these go to a working group. I think we'll see what session,
Right.
What we see from session, and there may be some bills that address some of these issues as well. So those would be just the two things I would add.
And for the general public and everybody's benefit, what we're talking about, the issue is the legislature makes law, and they do statutes like 508 of the property code, 5.008, that say certain disclosures have to be made in these instances. Likewise, the legislature allows us to exist as the Texas Real Estate Commission. And this committee in particular is a statutorily created committee. The legislature says we can exist and sets the guidepost on the authority under which we act. By taking certain actions like imposing new disclosure requirements, can that be read to us doing the legislature's job or operating outside of the authority that they have granted us? And even though we might see concerns and have recommendations from individual representatives and senators, that's a request that we have to look at, but it doesn't then give us permission to exceed the scope of under which we have to operate. So we're trying to stay within the rules and understanding these concerns that I know many of us share and think might need to be in there, but we have to be always mindful, especially I know with our governor's position and regulations and in legislating by agency action. Right. And so we have to be very careful not to do that because it truly lies with our representatives who we elect, who we as the people elect, not agencies that are appointed and have other members. Right. We need that as much as a direct action is my understanding of the position of our current governor and in general there. So that's what we're trying to discuss here and be mindful of. And I will say to the representative senators, we appreciate the thoughts and stuff and see how we can address it. And we're mindful of these other issues as well that we'll try to match up. So,
And we'll look forward to seeing if they bring these same concerns through in bills in session, which would really make it easy for us to do exactly what they want if it gets passed.
And that goes back to why we've always stood on the seller's disclosure notice only being what's required by the property code. In other transactions where it's not required, like some farm and ranch transactions, depending on the value of the improvements, vacant land, a new home, it's not required there. So that's when we look at more of the consumer protection in adding certain items. But with that, if there's any particular comments or questions on this, we'll entertain those. And seeing no hands raised, we'll put that with the subcommittee to look at and come with a proposal for the next meeting. Go back, make sure, are there any other items under agenda item 3? That's it. So I think maybe we take a short break here and come back at, I want to say, what time is it? 10:40? Is that a 6-7 minute break?
Yep.
Okay.
I'll mute.
Okay, we're back on the record. We'll move to agenda item number 4, and included in our materials was a report on the legislative session coming up. And I would tee it up for questions, comments after reading the materials. If anybody has particular questions about the upcoming bills, we can entertain those. And we have some are online as well who can help answer any of those. Okay, so seeing no particular questions there, we'll move forward to the working groups, which I don't believe we have any reports for this particular meeting from the working groups. We do have task ahead in some items that I know are particularly within our backup contract working group that we will discuss later today. We had deferred a couple comments from last meeting about a notice and potential other language for that. So we'll get to that here in a little bit. Next, our agenda item number 6, which is the discussion and possible action regarding comments received on the contract form proposed at the November 4th meeting, commission meeting. And starting with that, we had a couple committee member comments, or let's see, it's only the notice of buyer's termination. Sorry, starting with that. We have one form that we proposed. Well, I need to find in my materials. And I don't believe we received any comments on it.
Correct, no comments.
And did anybody on this committee have any additional changes or thoughts on the proposal that we made? And this is specifically to the notice of buyer's termination form.
This is on the page 11 of our packet.
Yes. Yes.
Actually, put that part of my materials here.
I'm happy to share the screen too.
Yeah, that'd be great if you don't mind on that. I'll try to find where I put the materials there.
Page 11.
Yep. And so wait for this to come up here. And so the only addition we made here was to account for our revised section 2A in the third-party financing addendum regarding the buyer approval. We added a new requirement there if a buyer elects to terminate based upon their failure to secure buyer's approval. They must provide a written statement from their lender setting forth the reasons for that denial. And so that's why we added to there's a buyer's termination to include that language. So with I believe next is to vote to push this forward to the commission for adoption. And so all in favor of pushing forward the revised notice of buyer's termination for adoption to the commission, say aye.
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 All against, say no.
Hey, John,
Yes.
can I point out, we did get a comment that was just put in this morning about the notice of buyer's termination of contract, where it was asked, is there a reason TREC doesn't include the ability to terminate the condo contract because of the post-contract executed delivery of the condo docs or resale? That was by Lawrence Henry, and it was a supplement that was sent to everybody this morning.
We don't have it yet.
It's in your email.
Yes, I see it. Oh, I see the attachment now, which I thought was the one that was printed here.
So this is there's two comments on Lawrence Henry on the supplement to agenda item 8 regarding that. I think we can maybe separate that issue. We need to have this adopted for the third-party financing addendum changes. And so I think we go forward with pushing that to adoption and maybe pick up this comment in agenda item 8 on whether we make additional recommendations
in the future. Yeah. Okay.
So you were in the middle of a vote.
Okay, so
We got the comment.
we'll do that
For no's. You just need to ask for no's.
Yep.
Okay, so all against pushing for adoption, putting forward to the commission adoption of the revised notice of buyer's termination, say no. Okay, so unanimous in favor of pushing it forward for adoption. Okay, we'll move forward to agenda item number 7. And this is discussion possible action regarding deferred comments and recommendations from committee members concerning possible changes to the contract forms. And so we had a few comments that were submitted by Mary and Ron. And so Mary's comment goes, into I would like to actually take up Ron's first, if it's okay, because I think Mary's comment will lead into our discussion about the compensation issue, which will take up more time. So I think addressing Ron's comment here, I'll let him describe what.
It's not a big push here. It's just the question comes up is what's a holiday, so that if the deadline falls on a holiday, then what holidays are we talking about? So I've always just said, well, why not just refer to the provisions in the government code? And then you had mentioned later that, trying to decide which part of the government code we want to reference as a possible solution. So I would think putting that on the list maybe as a possible revision for the next round.
And this is I think much more than a 5% issue in understanding what qualifies as a legal holiday under TREC contracts. I think all get that question quite a bit. And if you look in the TREC contract, it references a legal holiday, right? And so what is a legal holiday? And if you look at chapter 662.021, 662.021 is the subchapter in the government code that addresses what is a legal holiday. And that specifically says it includes a national holiday under a different provision. It's 662.003A, and state holidays under 662.003B 1 through 6. So if you go then back over to that particular section in 003, there's quite a few on this list, some of which I think would surprise many people without having looked at it.
Mhm.
And so I'm really in favor of adding this to the contract. We had another comment in from the material submitted that asked for this change as well. And I think it does cause confusion. Many people think it's just when the title company's open or banking holidays. And so by citing to this, I think we'll remove a lot of confusion and provide a lot of direction there. In doing that, I think we do need to cite to two different provisions. I think we need to cite to 021 and also to 003, because 003 can be misleading. It looks like it provides what all the holidays are, but there's two specific ones on that list that don't qualify as a legal holiday, and that's the day before and the day after Christmas. So to make sure it's complete, I think we should cite to two. And it doesn't need to be anything complex in my view. It could be a simple reference to that section right after the language of legal holiday in the contract itself. But, thoughts on how big of an issue this is and whether we'll like to see the change?
I think it would be good.
I always ask.
And we need to have it, yes, very, very specific. So, I mean, even when we say, I think we ought to say 662.003A and B, which are national and state holiday. I mean, I think we just need to spell it out and then make them help look.
And then here's the 021 section that says legal holidays only includes 1 through 6 of 003B. Everything in A, but only that. So that's when I reference, I think we need to point them here first and also to that. So they don't just go there and automatically assume it includes that 7 and 8.
So do we want to right now decide where we're going to place it, or we're going to defer that question until later? I'm just asking for the minutes or in terms of pulling up.
Well, hold on a second. Does it say legal holidays in the contract right now?
Yes, it does.
In the contract?
Yes.
Okay, so we don't want to change that. Okay, fine.
Yeah, and I think that
Okay,
it's
we can.
very common. Can we pull up the contract real quick? Maybe just highlight that, and
Yes.
it may be quick to make a proposal on this to move that forward and have one less thing at the next meeting.
Yep.
We have more materials.
That's a good idea.
Well, so I know that this is with regard to the option fee, right? So
in paragraph 5.
Right. So the bigger question that I have is, do you want to add this same idea about extending on a legal holiday on all timelines in the contract?
I am not in favor of that. I think that there's lots of different timelines that run. And by having just a general sense that we're moving to a business day versus calendar days, would be a drastic change. that we would definitely need to look more into. So at this time,
Well,
I'm not,
You're not moving to business days
No.
because you're only talking about the
oh,
deadline.
sorry, the deadline.
The
Yeah.
deadline. So let's say you're running out of
That's
your
right.
time for objections in paragraph 6. Do you want to, and it falls on a Saturday, do you want to extend to the following Monday? Same thing with any other
Closing date.
date or anything else. That's my bigger question is that, or would you want to address this only in paragraph 5?
I want to be consistent. That's another thing that I think is really important, that we are consistent with. I mean, unless there is a very specific reason we need to explicitly give a definition for some section, I think we should be consistent. I mean, it's well known that we are not business days. We're on calendar days. That's a thing. But
Yeah, my mind drifted on
Yeah.
that topic.
But
So
the
usually what happens.
holiday,
I'm sorry.
go ahead.
So usually on the non-track contracts I negotiate is we'll have a similar clause that applies to all of the timelines in the
Yeah.
contract. And it doesn't seem to be a problem because sometimes we'll change and move those and we're not paying attention.
Yeah, I think that's the only place it appears right now. And I think that would be a pretty big change to move other deadlines past legal holidays potentially. Not to say it's something we would need to look more into so we don't make a change that then has unintended consequences.
Difference between definition and then a substantial change for process and procedure.
Well,
And-
okay.
and
5. Go
This
ahead.
is just bringing up something different because we're looking at days and stuff. Has there ever been a discussion, because I know it's in other states, that there's a sheet that puts all the dates, from the time we put things in the,
Like a critical date list.
yeah, I get it at Colorado, I get it at Utah. All of a sudden, the first page is, these are all the dates that you have committed to. And they're all signed. So that way everybody knows the dates.
Is that a promulgated form or is that something that's produced
I
on?
don't know if Utah promulgates, it's a Utah contract. I think it is, right? Yeah.
It might be something
It
we
doesn't
can,
come from the commission. It comes from the Texas real estate, whatever, because they don't work off the commission at Utah. They do something different. I just thought it was interesting because it was like, that's really a cool, because then everybody's acknowledging at the end, we've agreed to all these dates. You've put them in the contract and now.
and this is where it's great to have the broker perspective, boots on the ground, right? This is one, you have the lawyer, perspective here, or something that'd be helpful. It would be a change and maybe looked at broader and making the definition versus substantive changes in concerns I would raise on the lawyer side to that is, what if there's a conflict between what the actual date is and what they input separately at the end, similar to the confusion we see in compensation that doesn't match up between the CAVB and the page.
It's auto-populated.
But not all. So in here are forms when they pull them offline, if they're used for the general consumer, that would be
Yeah, the one in Utah is auto-populated. It just shows up.
and that's where I was thinking maybe like the association has it as a kind of their benefit to add to it, to where they can have auto-populating of the deadlines and through their software programs and such to remove that. But any thoughts on that, since we're on this topic, and maybe looking to do a definition now as we have on our screen of a legal holiday, then for a future meeting, looking at the broader sense of the deadlines in general, whether they should be extended if they fall on a weekend or a holiday?
Well, the simple one is to simply say that legal holiday, just add a sentence at the end of both of those paragraphs that says that a legal holiday is defined, or a legal holiday means a legal holiday defined by 662.021.
Yeah, Texas
I like
Government
that.
Code.
That's all I have
Yes,
to say.
Okay.
I agree.
Yeah.
As to the other issue, I think that I'm not up for that now. I've heard, this is the very first time I've heard of this in almost 12 years. So I'm not apt to think that even
Which
You
one, the
know,
critical date list or
having
the?
date list
I
in
never-
the contract.
I never
and-
thought of it until I did a contract in Utah on the contract.
Well, it's very common in commercial deals. It's a very common thing to do, and
No,
a lot
it's
of
very
title companies are doing that just in
People do
general
it.
now.
I agree, people do it, but to make it part of our contract, I am not, I don't,
I agree with you, pretty drastic action to take, remove the conflicts, but it is something that is worth a discussion still, I think, to see. But I do feel your sentiment on.
Well, I would suggest that maybe Mary turn in a contract. I mean, send us the contract as a sample and send in
We can do that.
notice so that we'll actually have the comment ahead of time for the next meeting with what you want.
I just came up.
And
with the
also that way, anybody that likes to stalk what's coming up, that they can look at it
And it
too.
flows into our looking at the broader deadlines
Yeah.
as well, right? So we need to know what the deadlines
That's why I
are
was bringing
for-
it up.
for the other ones. We'll start with Christy, then Melissa.
So if we're going to add in the definition of a legal holiday by referencing the code, we would likely need to do the same in the addendum for backup contract that we just updated because it mentions legal holiday in that as well.
Yep. And anywhere else, really.
And-
That's a good point.
To go back, if we define it once in the contract and the addendum's part of the contract, if we make that like a big L and big E, can we then continue that on without adding additional language to the others? I think we do that for
Yes.
the effective date and things like that.
Yes, that's a good point. Just got my coffee, so I'm step behind you, yes.
Does that make sense, Christy, on that, if we make it a defined term, then have it continue on?
Absolutely. I like that without having to change any other forms. I just wanted to make sure that there was no confusion since agents seem to get easily confused with things that they're not going to say, well, it was here, but it wasn't here. So I think a defined term is appropriate.
So we should go back though to the form and make sure it's capitalized.
Yes, everywhere, just like escrow agent, we just make capitalized. I think we need
Right.
to go look and make sure everything's capitalized.
We need to make sure Abby or whoever's in charge of all of our actual redrafting. So do we need to re-vote on that?
I don't think we need to define it again in addendum.
No. We need to capitalize it.
Mhm. If we make it a defined term.
Do we need to re-vote on? I think we need to re-vote on that.
Well, I think we're just putting it in the minutes to have a draft of the next one to consider.
So the one we just pushed forward, we just pushed it forward without the capitalization.
Notice of buyer's termination.
It's not in there. Oh, different.
Yeah, backup, the backup addendum is what, and we have to look at it
Drink
in
my
the other ones
coffee and
too.
try to be quiet until it kicks in. Sorry, I'm sorry.
So, do we need to give you a minute for the minutes?
No, but even if we do put the definition of legal holiday as capped, then we need to make that change in the addendum because we got to capitalize it now.
Correct.
Okay.
Any other addendum that might appear, none immediately come to mind, but
Well, and I have a question on just the way we want to draft it in that paragraph. Do we want to put the definition as the first part of that
I think it
parenthetical
actually
two?
worked in the last sentence.
Okay, well then, but you still have to capitalize legal holiday twice before you define it then. Follow me?
Mhm. Well, I think if you capitalized legal holiday and put that in quotes and say means a legal holiday, which is not capitalized, defined by section 662.021,
Right.
then you're okay. We'll look at the draft and we'll get into the fine point about capitalizing later, but I think we're okay.
okay, so then.
Well, can I ask
Oh,
the
sorry,
question?
Melissa, in there. Go ahead, Brian. Melissa, if you don't mind.
No,
That's
Melissa was ahead of me.
Well, I just had thoughts on the section. I went to look up the government code that you guys were talking about, and it was saying it covered state and federal. And I feel like in the spirit of when this was first done, it was probably more along the lines of the federal holidays, because the state holidays that are listed is like San Jacinto Day and Emancipation Day and Texas Independence Day. And while these are great and they are celebrated, and I love the fact that we have them, I'm not sure that those are days that a buyer couldn't or shouldn't go and and take care of the things that they need to do. And they may not even know it's Texas Independence Day. You know what I mean? So if we
missed the
do it,
reference.
I would rather it just be 662.003, which is the federal.
No.
A is a subsection A of the 003. And so that brings up the substantive thing of what was meant, with our contracts right now, right? So we have this contract that's in existence. In the understanding I have is legal holiday is what this is included in the government code. And so I think we've been operating maybe unknowingly, but within that parameter of including both state and national. So that raises a question on the practical side now of, do we want to limit that? Do we want to change what the underlying law may have unknowingly been to a lot of people in the contracts? And so that's a great discussion point.
But you need to look at 021, which is where this same conversation happened with me and John here too, and I was doing the same thing, but it is more limited by, isn't it 021?
It's a day before.
Yeah, 021.
Day before, day after Christmas are excluded when you go to that provision. Right. But the other ones like Texas Independence Day and others that people may not realize are legal holidays, I think
they're a state holiday, but they're not a legal holiday, if that makes sense. So if you go to roll down and what you're looking at to section 662.021. So it includes all the national.
Right. So the terminology would be different depending on where we land.
Yeah.
National holiday,
right.
state
holiday or a legal holiday. But the government code says a legal holiday includes all national holidays and some, but not all of state holidays. Right. And the state holidays are what's listed in, well, both of them are listed in 03. So you did exactly what I did. But where you would cut those out. If you're looking at 003, the second section, you cut them out.
Except the one she's raising, like Texas Independence Day, which is still included.
Well, I don't know. I think.
And
considered Heroes Day.
What was your thought, Brian?
Well, I think Melissa stole my thunder. We need to be careful. We don't have too broad of a description of what we're excluding as a legal holiday. And
the code did.
Pardon me?
Well, we didn't exclude anything. The legislature, when they wrote the government code,
well,
021 section.
That doesn't mean that we have to include it for purposes of this contract. That they don't.
Yeah, and so the question is, that's what it is now. And so do we want to look at the substantive change of limiting to what many probably already think are what qualifies as a legal holiday? So we have what's over here that's just kind of been an unknown, kind of like our old disclosures in the contract and that nobody knew about until we put check boxes in there, right? One thing we should know, but we largely operated without. So now that we can educate and say what they really are, do we want to limit it? We want to change up to what may be the general thought of what it should be.
Well, here's something we would have to look at before we can answer this. And I'm willing to put a large wager that the courts have used the term legal holiday as defined by the government code if they've interpreted this. And I can't cite you to anything.
Well, nobody's disputing that. I think the discussion is, being that's how the contracts are to be read, do we want to change it going forward to make a change?
No, I don't. I think that also would cause a tsunami of extra.
And this is where I invite all comments, right? So because there are going to be multiple different sides potentially, and to Melissa's point and Brian that expressed as well of many people may not realize that and not read it. And if we cite to this, do we want to really be that broad? Do we really want to include all these other ones that title companies are open on, people are doing deals, and is that part of the practice? I just to for other comments too and thoughts on that. I don't think we're not making a decision today, right? So maybe this is something we get comments in for our next meeting by those that are listening and look at that. I like whatever we're doing to be a good definition so there's no confusion.
Exactly. Let's get it right. We don't have to use any particular thing. If I had a buyer who was supposed to give notice of termination on January 19th and they send it on January 20th, and the seller says, you lost your right to terminate. And he says, you got to be kidding me. Don't you know that January 19th is a legal holiday because it's Confederate Heroes Day? I had the right to terminate on January 20th.
You'd win right now, I think.
Yeah, you
Yeah.
would. You'd win
And
right now.
I don't think that that is the intention of 99.9% of the people that deal with the contract form.
Why do you think that?
Well, and remember, this is only for the delivery of option money and earnest money. This isn't for the termination itself. So we're only addressing, at least now, maybe some of the addendum language as well, like the backup. But in
Right.
at least paragraph 5, it's only delivery.
But we should be.
You're right. You're right. You didn't
Consistent.
deliver the money.
I'll
I
give
misspoke.
an argument as a good argument because again, I think we ought to be consistent. So if it is applicable elsewhere,
Can you put that on the screen, the list of
Legal.
holidays?
ought to be,
You want to pull that? Or I've got it up if you want.
Well, maybe walk through this so we can get the, especially from the broker's boots on the ground perspective, what do you generally understand as a
But those are
holiday?
cut out.
Outside any legal definition or rules, what in the field do your clients and your
If
agents?
the title
feel?
company's closed.
And that's what, and that's,
Exactly.
we jumping around say that, but which of these days falls within that?
but these are state holidays, not legal holidays
Yeah,
as
so you-
defined. So you don't get the 19th of January.
Well, you do.
No, you
So
do.
No. 1
7
through
and-
6 fall
Six
under
is-
B1 through 6 are legal holidays.
It's only 7 and 8 that are excluded.
So
Yeah.
down here, 2-1.
Fine. I'm glad about San Jacinto Day. See y'all.
There's 021.
Pasadena.
So the term legal holiday is defined here to mean a national holiday, state holiday, but states are limited 1 through 6. So you go back up here.
Christmas Eve and the day after.
Right.
Exactly.
So Texas Independence Day, San Jacinto Day, the aforementioned.
Confederate Heroes Day.
Of course, Emancipation Day and LBJ Day, Friday after Thanksgiving.
I think you ought to put all of them in.
All right.
I mean, quite honestly, if I had to, if somebody asked me what it should be, it would probably be all the national holidays and the Friday after Thanksgiving, from a practical standpoint.
Yeah, you're probably right.
Well, the
Brian,
title's
you're with
open
it.
those other days, right?
Pardon me?
Is title open those other days in most cases?
Okay, let me ask this other question. What about the banks? I mean, that's the other party that we really care about. Are these banking holidays in Texas or not?
I don't think, this is under the state employee holidays section. This 003 is under that subchapter. And
You raise
so,
a good, you raise a good point, CJ, SJ. And that is, you often see commercial contracts tie legal holiday to the days of the Federal Reserve Bank of the area where the property is located. You see that in a lot of commercial deals.
And a deja vu. Did we talk about this sometime?
we've talked about legal
Yeah,
holidays
too bad. Yeah.
several times.
Now you know why we haven't ever done it.
That's a,
Just saying.
it's,
3 months, Amy.
it means this right now, right? So if somebody wanted to go argue and make a legal fight, this more than likely, this is what it's meant by it. Legal holidays defined. And so I think this is an issue as tough as it is, we need to address either by making it very clear, this is what the holidays are, citing to this section, or make a firm decision, at least do that, bare minimum, and then make the hard decision on do we limit it, which is the much harder one.
Well,
to
and
manage.
I'm gonna also raise the flag again. Chair Kessler is not here, but we are honored by Chelsea being here. We could get all excited about this and then the commission doesn't agree with us. Is there a prevailing thought at the? that
We have
need
not
to-
talked about it, so
Okay.
I do not know. My one thought is that, state holidays are different than national holidays. And if I'm not mistaken, national holidays and bank holidays are connected. So the one that comes to mind is like Columbus Day. That is not a state holiday, or you can call it something different now. Emancipation, no, I'm sorry.
Indigenous Peoples Day.
Indigenous-
Yeah.
Thank you.
Indigenous
I'm
peoples.
losing my words. That is a day in state government that we are open, but the banks are not open and we don't get mail, right? It's not a national day. So I don't have an opinion on any of this, but I want you to kind of think about whether,
Well,
it seems pretty simple to point to the state holidays. There may be a quirk or two.
And you do actually have Commissioner Renee Harvey Lowe on the call too,
Yes.
so you can.
She may have ideas.
yeah. And this isn't, you just real quick, that Indigenous people in Columbus Day is not listed as a
Right,
national
it's not
holiday. The state has decided it's not a national holiday, but it is.
Well, the state is not a
state
state holiday. So it's
No, but
so state
it's-
employee, so it's not on that list because it's not a state holiday.
Well,
It's not like a closure day.
it says a national holiday includes only the following, so we are.
Oh,
It doesn't necessarily, the statute doesn't necessarily tie into what is
the
national.
actual,
Yeah, so,
what the
Right.
nation considers to be the national.
yes, Texas has
Good.
nationized the national.
That's fitting.
Yeah.
I like that.
Maybe we should ask the commissioner if she has any thoughts.
Actually, this is not Renee Harvey Lowe. That has not been a discussion.
Oops.
I think a federal holiday is the safest choice. I mean, everybody knows what that is.
The federal is different than national. That's a good point,
I'm
Commissioner.
sorry. Yeah, I'm sorry. Say it again, please.
I do think a federal holiday is a different thing than a national holiday, and I'm glad you said that.
So, it's thematic. What I think we pick a lane, and or at least discuss that.
Is
But
there
as
anything?
far as state,
Sorry to interrupt.
I'm
Go ahead.
sorry. No, that's fine. But as far as state holiday, we can't. I don't see that there's any way that would cause havoc. I believe.
Oh my God, yeah.
See, that's an opportunity to report on these discussions and see if there's feedback at the meeting.
I think that'd be great to highlight what it is now and not understood to how we should change it to how everybody operates and maybe look at specifically which days, if we move to the national holiday under 003 only, are there any additional days out of B we want to include, like we were mentioning the day after Thanksgiving?
Yeah.
B6.
Yes.
Maybe that's the thoughts on that at the commission to provide that definition so it's clear and people will know. And then that'd be easy to get on to. I think.
Ron, I just sent you a link of the Federal Reserve holidays, if you want to put that up, just for illustration.
So there's Columbus Day. So basically, they're all the same except for Columbus Day.
So they're the national holidays.
Well, they're federal holidays, not national.
Federal.
Texas national holiday.
Federal.
A lot of definitions around here.
Does anyone know what the title companies use as a guideline for when they're closed?
Oftentimes, there's no rule, but oftentimes title companies will close on bank holidays because they're not going to be able to fund transactions on that day.
And does
Because the
bank
wires are
holiday
closed.
equal federal holiday?
Federal Reserve, the
Right,
dates on
right.
which banks at the Federal Reserve are closed because you can't send wires on those days.
This
So-
makes so much more sense, practicality speaking out in the field than, and I know it's not, I think somebody a moment ago said, having a right to terminate, and it's not a right to terminate for the
Right.
buyer because they might or might not have that option period and all of those things. But it does affect rights to terminate because if the buyer doesn't deliver the money, the seller has rights to terminate. So it's an important piece for sure that we need to be clear on.
So there's the banking holidays and but if you want to cut the conversation short and defer, I'd recommend, since we're not seeking to change the term legal holiday, then 662.21 applies. So we're not changing anything by referencing that.
And then we can look at if we want to further define it. So we have now of adding a definition of we'll put that in the draft for next time. Get the commission's thoughts on the holidays, including all of A and B6 of O3, and then take it up at the next meeting.
Yeah, and Abby mentioned the thought of, we could briefly include in the report at the meeting, but maybe this is a workshop similar to what we did. It's not a formal recommendation, but this is the discussion point, and walk through some of those some of those different holidays at a more detailed level in the workshop versus the full.
Get their feedback.
Yeah, because I mean, it's like Commissioner Harvey Lowe, she's like, oh, she's doing the same thing we're all doing, which is like, I don't know if we haven't looked at all of these things, and that's right. So this would be an opportunity for that to happen.
And I just started including this in my classes here recently that I've been teaching, and it's deer in the headlights look when everybody sees the list and what actually applies. So it's definitely right for fixing. Okay, well, with that, any further comments? If not, we'll move forward. Okay, so question is, and I think this would be a good part to go ahead and jump into the compensation discussion. And Mary has a comment on this. We do have some other comments on other issues that we received, but those are fairly limited. I think we can bring up at the end. And so I would like to tee up the what we've done real quick, a little quick summary, and then where we are looking at in the concerns that have been raised and some of the confusion that's out there. With this compensation issue, we know it's complex, and we know that there's been practices for a very long time that are hard to forget and relearn new ways of doing business. It's just the nature of it. And unfortunately or unfortunately, depending on how you look at it, lots of different forms have come out, not only from, not really from the Texas Real Estate Commission perspective, but from the trade association perspective, from Texas realtors, from individual attorneys, from individual brokers. There's been so many different forms that have been in the marketplace. The intersection of these forms and the changes are really hard to keep up with. What we did at our last meeting, last few meetings, we're trying to work on language to advance it, to simplify the process, to account for the new way that business is being done, or the changing way of that business is being done. And we took what we said was a first step. And the first step we did was to add in paragraph 12 a seller contribution towards broker compensation that the buyer has agreed to pay. And we'll get into what that means or doesn't mean coming up, but we took that as a first step to help clarify. Outside of that, these other forms that are out there and referred to as the CABB or the 2402, 2406, 2401 are not Texas Real Estate Commission forms. But at the same time, they intersect and interact with our forms, our TREC forms. And so we're mindful of that interaction. And I know there's confusion out there that's expressed, and Mary and I had a call to discuss this on different things that kind of highlight or highlighted in her comment that I'll let you go through and tee up here. But what paragraph 12 is intended to do is to be a direct contribution out of the seller's pocket directly to pay for buyer broker compensation. And it's capped by the amount that the buyers agreed to pay. And so the language in there is at X% or X dollar towards buyer compensation that they've agreed to pay. And so if you have X dollars in there, but they've only agreed to pay Y, which is less, you only get Y as a contribution. If they agree to pay more than that X, they're not getting more than X. It's just the amount that is put in the contract. The key distinction here to remember is on page 10, right, which is, that's the end of the contract disclosure, is informational only.
Correct.
Information only is not binding. It doesn't matter what's put in there, shouldn't matter what's put in there. What is intended to be put in there is how much the listing broker is paying out of their pocket to the buyer's broker, which what we always knew as cooperative compensation, the MLS offer of compensation, the new 2402 offer of compensation that is agreed to. And so any amount that you put in 12, which is out of the seller's pocket directly over to the buyer's agent compensation, is different from page 10/2402, which is out of the listing broker's pocket and over to the other side. And so the amounts in that, I'm going to tie them together because page 10 and 2402, that is very common use, are this payment. Paragraph 12 is this other payment. They stack on each other, right? So it's an additional amount. And what we have to be very careful of as listing brokers and as sellers is not over obligating ourselves or our clients by putting an amount in 12 and also having a 2402 that's enforceable, because our seller is going to be responsible for paying both directly out of their pocket in paragraph 12, and then out of their pocket again, but to their listing broker, then over to the other side, right? That's how the 2402 works. The seller's funding it, but it's the listing broker paying it. There's two different payments. And so I think a good way to look at this and where the payment's being made, understanding that paragraph 12 in page 10/2402 is different. And if you have the 2402 that's already signed, enforceable, as a listing broker, we need to acknowledge that's already established. That's an enforceable agreement that's signed between the brokers. And that payment's being funded by the seller and listing agreement. Separately, listing brokers and buyer's brokers are not parties to the contract. And so in paragraph 12, that's only the seller agreeing to pay. And keeping those separate, I think, is where a lot of the confusion has been had. And we see a lot of the comments saying, well, do I, especially in the general industry, well, you put the amount in 12 in page 10. No, those are different. Or page 10 is enforceable. No, it's not. It's a disclosure only. And once we get the education, I think, to have to simplify the process of make sure that the total between the two, however you structure your transactions, add up to what the seller intends to pay. That's where we need to arrive. And we'll walk through the confusion and questions. I think that will help clarify that. But it's a relatively simple way of doing business at the end. Now, whether that's the way people want it, there's a lot of comments on here that we want more. We want farm and ranch. We want disclosures. We want all these things, which we've agreed if we took a first step on, or we're going to look at those particular changes, is a separate issue. But I think that the way of doing it in the contract is fairly simple at the end, once we can realign ourselves to what it means, unburdened by the past, right, of what we've been in, which is another politician's phrase that I'll leave out. But with that said, I do want to say that we talked about prior meetings, and for the public to know, if we wanted to see how this operates in practice. This is brand new. It's only been out there, mandatory use, for about a week. And we know there's going to be confusion. There's going to be a learning curve. And so we don't want to keep changing these contracts up every time. Even though we have a lot of comments, a lot of questions, we want to see how it operates in the marketplace and still be nimble. But I think we're too early to know if this, what hopefully is a simple way of doing things, can be learned and have the education out there to help the misunderstanding. At the same time, being open to changing in the future. But I think now, setting table, we're pretty early, unless there's drastic action that we think we need to take to do anything else, to keep changing it up just because of certain comments. And we spent for those who weren't in our past meetings, we had, I think, 11 hours of formal meeting time and hundreds of hours outside of that, taking in all the concerns, all the options, all the considerations to arrive where we did.
And there were lots and lots and lots of concerns that were expressed through comments in writing and live.
And we went through all, I think these past meetings are available on Trek's website. So if you go and look at the past broker lawyer committee meetings materials, there's links to the videos that you can look at both what people submitted, the video discussions that we had that addressed it. So when we talk about it today, we're bringing that collective knowledge forward. We're not just starting from scratch. We have the bit that we'll try to tie it in to the extent that it informs our discussion. But no, just because we don't discuss a certain option or a certain way of doing it, it's not because we haven't already. We're bringing that knowledge forward here, and it's available for anybody that wants to go view those past meetings in July and June and July, I believe, were the two meetings we discussed it. But with that, Mary, you had the comment on this. I'll tee it to you.
Okay, this is a cluster, and I think I was asleep for a year. That's all I can say, because I'm looking at this going, I didn't interpret it this way when we were sitting at this table. Okay, and the reason I didn't interpret it the way it's playing out right now is because the 2402, 2406, whatever, is a Texas Realtor form, and we're a promulgated contract. And if you look at the settlement, they said, make everything transparent. Take it off the MLS and let's negotiate between the buyer and the seller. If I use a 2402, I am not negotiating. All I've done is taken that number off the MLS, put it on a piece of paper and sent it to you and said, this is what I'm paying. I did nothing except take it off the MLS. And I now am still dictating what you are worth. And yes, in 12, you can ask for more. I get it, but you're still dictating. I don't think there's the transparency. As I've talked to you, short version, and as Jay with Farm and Ranch, maybe on page 10, then you just put a signature that the buyer and seller know where their money's coming from. Because I think right now, we're not transparent because the 2402 is nowhere between the two brokers. No one sees it. They don't, and they don't see the listing agreement. The seller and the listing agent see the listing agreement. 2402, the two brokers see the form. We don't have transparency with what they've said in this whole settlement between the buyer and the seller where the money's coming. I was thinking we were putting everything in 12. You know, if I called Abby and she said, yeah, we're paying 3%, she's not giving me a form. All I'm doing is dictating, just like, you know, that I was putting the money in paragraph 12. So I think there's a disconnect. I think, or like I said, go back to the Farm and Ranch or get some kind of signature transparency with the buyer and the seller knowing where the money's coming from. Because we've changed nothing. We've absolutely, if I use a 2402, I've moved it from MLS to a page, to a piece of paper. Paragraph 12 is not filled out. I've absolutely changed nothing. I'm still dictating the compensation unless, like I said, the buyer's agent's asking for more and they can then ask for more in paragraph 12. But if they're going to go along with the 2402, we've changed nothing. We've absolutely
Well, hold on.
changed nothing.
I want to make just an observation, though. You know, the 2402 is a contract between the brokers. And when you present it, that's not even a maybe, that's the law. That is a contract. So there is an offer made when whoever fills it out first sends it to the other one. And they either are going to agree to it or they're not. And yes, y'all may come to an agreement right away, or you may not. In your example, if Abby says, we're not paying, and you say, well, I'm going to send you this anyway, and you put in 2%, or she says she's going to pay 1% and you put in 2% as your offer, there is a negotiation going on, and there is a separate contract. And the reason there's a contract is because, again, we've worked real hard to make the brokers not parties to the real estate transaction contract, one asterisk, Farm and Ranch notation. But y'all, you know, the brokers and the agents are not a party to the transactional contract. And if you want to get paid under the law in Texas, a real estate commission, if you want to enforce it, it's got to be in writing. So this is your contract in writing.
But not between brokers, though.
But it's between brokers.
Brokers does it. But two things to throw in, or a few thoughts to throw in. The fact that, address the comment that we haven't done anything, or we've been very careful in what we've done here in the concerns that we're not, Trek was not part of the lawsuits. We're not part of that. But there's other practice changes that have addressed beyond that address the concern that is tied into the 2402 being used in the requirement that the removal of the requirement to even offer any compensation, right? If you're MLS, you had to make an offer before. That was these are NAR rules. We also address the buyer, the listing agreement of netting of fees in certain situations. Before used to say that you kept everything, right? And if whether somebody's on the other side or not. The buyer's rep now, the MLS rules require that you agree to the amount with the buyer in there and to have a written agreement before touring a home. And so there's these other things that have mitigated some of these the lawsuit concerns that the just saying the use of 2402 is the same as the MLS. It's I think a little bit broader. I look at it a little bit broader than that. I agree. Functionally, it moved it from MLS to the 2402, but tied in with the other ones, and in my view, kind of address some of those other concerns. Now, the transparency aspect in our contracts, we have is very close. Last time we had that farm and ranch, and when we looked at this, we were one vote from continuing to consider that. And I think that's still a big desire out there to look at, and in terms of, is that something we want to move to in the future at some point? And because that would have everything built in, and then SJ's concerns about agents being part of the contract and signing it is thereby creating potential bigger liability.
I'm not asking them to sign it. What I'm saying is a statement, even in the contract or on page 10, that the buyer and seller know where this money is coming from, because we don't have transparency from the buyer and the seller. What I'm saying is it's still coming from the brokerage. I'm still dictating as a listing agent. Yes, I've had my conversation with my seller and we've come up with a number. And I've decided, we've decided on a listing agreement, and it's confusing at even with compliance. And I'll say even with, because I'm with a large company now, even with compliance, what they do is they go look at the listing agreement and they go, your 2402 has to match. Right. And if you want different than 2402, you can't put it in 12. I said, yes, I can. If this one says 2 and that one says 2, but I want 3, I can still ask for 1 in paragraph 12. And it's really confusing compliance because they don't understand how all the apples are going together.
Would it be?
Yeah, I mean, I think.
Sorry. I was just going to say, would it be helpful to have Robin maybe explain what 2402 is?
Yeah, I think
I got one right here.
That'd be great. Do you mind us putting you on the spot? And
sorry, everyone keeps mentioning 2402 and throwing the number around. 2402 is the Texas Realtors Forum compensation agreement between brokers that, as SJ mentioned before, is the contractual agreement between the listing broker and the buyer's broker on
This page, not the other page.
compensation that will come from the listing broker if that cooperative compensation is agreed to by the seller. I know there are people watching who may not be familiar specifically with the Texas Realtors forms and form numbers, so I just wanted to clarify that. Thank you.
But then they got rid of the 2406, which I love the 2406. I mean, if we would have talked about the 2406 the whole time, I'm okay, because the buyer and the seller are agreeing on the 2406 where the money's coming.
Well, let's look at that. Let's look at that, because the 2406, which is the addendum, what was it? This is no longer available, but what was it called?
I think it's flipped on the other side.
Addendum, I don't remember the addendum for compensation.
Addendum
regarding broker compensation.
So the 2406 was a Texas Realtor form that is no longer available, that had effectively, for this conversation, 3 different sections in it. One of the sections had an incorporation of the 2401, which is effectively now in paragraph 12, right? That was an agreement, but it's informational only in the 2406.
Right.
It just said in a separate written agreement, this is what they agreed to, is informational only. Then we had the second section that had the reference to the 2402, in which but it stated even in 2406, informational only. And now that's been moved to, or not moved, it's always been there, of a disclosure in 12. Again, informational only, just like it was in 2406.
But the buyer and seller signed it. And that's what I'm saying. They were asking on transparency. The buyer and seller were signing. That's the first time we've ever had the buyer and seller acknowledging where the compensation was coming.
Barry's point here in our discussion that we had on this was the page 10 disclosure is outside the contract. It's below the signature line. They're not agreeing to acknowledge in the contract itself because it's contained beneath the signature.
And I've taught that for 10 years, and now it's making me change that whole theory.
I don't think it's any surprise that we are moving to a situation where we're no longer going to have shared fees in the future. Okay. Well, I should say prearranged share fees, so that we'll end up doing is listing brokers will say, go show the property. Buyer brokers make the offer. The buyers put in some amount in paragraph 12. And if he agrees, then we're done and there's no other agreements. I think we're going to be moving to that. Now, we could have the situation where the buyer refuses to do that. And then the listing broker says, okay, I'll share some of my fee with you and I'll negotiate that out with them. So I guess that's a possibility, but I think we are moving to the situation where we're eliminating shared fees. I don't think it's a surprise.
I don't think we will, as long as people keep supplying the 2402. As long as I make it
No, but
easy,
we
for
are-
the last
we
50
are in the-
years, the MLS was easy.
I understand, but we're in a transition. These things
Right.
don't happen overnight.
I mean, EXP's done it.
Right.
EXP has done it across the board. So if you're working with an agent with EXP, they do not pay
Let's not
brokerage.
talk about specific.
Oh, okay. Okay, a big corporation. But all I'm saying is they've made it a national thing. It's not just a state thing. It's a national thing. They're not paying brokerages.
And we have you
I
want
guess the question that I would throw out there is, for the next round of forms, what's the harm of deleting what's on page 10?
And so I'll tee that up. I have my thoughts, but I don't want to talk the whole time. First stand up is Brian's.
Okay, first off, I've been giving webinars about this, about the new contract changes. All they want to talk about is 12. I've been talking in-house with our people as to how to interpret these contracts. To say that there's confusion in the industry and with the public is a gross understatement. They don't understand what is going on. Agents don't understand. The public don't understand. Title companies don't understand. And, you know, we've had problems with this committee where we've drafted something that was absolutely crystal clear to the members of this committee. If you remember the addendum for right to terminate because of the lender's appraisal, we had to redraft that because even though what we did was good, it wasn't being understood and it wasn't being used properly. And I've tried to figure out what is the problem that we have here. And the problem, as far as I can tell, is that we're forcing people to connect the dots because we have paragraph 12, we have page 10 disclosure, then we have other agreements that are not a part of the contract, the buyer rep agreement, the agreement between brokers. And by golly, the people that are using these forms are not able to put them all together. And it seems to me, just as a global statement, the solution is we have to have one piece of paper where everything is tied together, a Rosetta Stone, if you will, where everyone can see on this one piece of paper, this is what the commissions are, and this is who's paying them. And we don't have that. And until we do something where we have something simple for Joe Bob, the consumer, to understand, we're going to continue to have not only people not understanding, we're not going to have disclosure, and we're going to have people making mistakes in when they fill out these forms. And that's going to result in lawsuits.
Yep.
So I think we have to go, and I loved the provision that the document that the TXR had that they pulled off the table. And I don't know why that is. And perhaps it's because of continuing antitrust concerns with the Department of Justice. I don't know, but we have to have one piece of paper. And if we can have that understanding, then we can talk about how to draft it.
So this piece of paper, to continue your thought process there, and you may not have this other than seeing out the issue, but are you seeing that as an addendum that's signed? Are you seeing that as at the end of the contract, including that above the signature lines as a, just in the contract itself, or below the signature lines, like a disclosure we have now, but with all the blanks listed? Do you have a further thought on where that might end up?
It seems to, I don't know. It would seem to me a separate piece of paper, an addendum, probably would be the safest thing to do, because you don't have to have this. You could, you could have a no broker deal. You could have one broker, a listing broker only where the buyer's not represented. You don't have to have it on every deal. And so it does seem to me, though, in the majority of the cases, it would be valuable to have that one piece of paper. I personally would make it an addendum, but I'm not wedded to that. It could be a page after the broker information statement.
Christy, your hand's up next.
Yeah, so I think we all know, one of the ones who originally really wanted a separate addendum and modified that point of view as we went along. And I personally, from practice, we do a lot of contracts every month and a lot of closings. I'm not saying there's no confusion, because there's still a lot of confusion. There's been less confusion with having it in the contract in 12 than there was with the 2406. Because a lot of people, I think even when we looked at the comments, the last meeting we were together, the large number of confusion and comments over don't make it a separate piece. Don't do something separate. Keep it in the contract where the client sees it. And I really think the bigger picture is an educational piece. Truly, if someone read what the disclosure says on page 10, it's self-explanatory. They're not reading it. If you read what's in paragraph 12, it's very clear. One, I think agents don't understand the path of money, whether it's coming through cooperative broker compensation. And the transparency comes in when an agent gets a listing agreement with their client and they have the conversation around whether or not they're going to offer cooperating compensation. And when an agent calls and asks, are you offering BAC? That agent knows, based upon the listing agreement, what's already been authorized to share if they're using the TXR form. I know some companies have their own listing agreements, as has been mentioned. But that is how that is taken care of in transparency with the seller. There's transparency with the buyer through the buyer rep agreement and knowing what they are being hired to get paid. And I also think we have to be careful when we make statements on the buyer's agent just puts in paragraph 12. We should never be putting anything in a contract that our client, the buyer, has not directed us to put. It's the buyer asking the seller for money towards their buyer's broker's fees that they've agreed to pay in their buyer rep agreement. So I think there's a lot of education pieces around here. There is a lot of confusion, but the confusion I'm seeing is people not reading and understanding the difference. And I do get that the fact that the disclosure on page 10 is separated, maybe part of it, maybe it all needs to be together. I don't know what that looks like. But what I am seeing a lot of is people using, putting the same amount in paragraph 12A1B that they are on page 10, and we're having to catch a lot of those. But I see less confusion now than I did with the 2406, but I don't know what other brokers are seeing in their businesses.
Melissa, your hand's up next.
I agree that it's less confusing now when I'm teaching, right? Because I spend a lot of time teaching, and I've taught the contracts class twice in the last 7 days, and because it's only been out for 7 days, right? And I think that's just not enough time. I think we can't make any changes based on a 1-week trial in the real world of what's going on with the contract. But as I'm having these conversations with real estate professionals from lots of different brokerages, some are saying, wait a minute, I didn't even know you could still do broker to broker compensation. They might be with a large corporation that doesn't allow that. And so we're having some conversations, not just about TREC forms, but about the TXR forms and what is allowed in those buyer rep agreements and listing agreements. And if they are in fact using them, I think that some corporations, some brokerages are going to, if they haven't already, make changes to their internal listing procedures and buyer representation procedures, whatever those documents might look like, that's going to help them have some clarity for those agents. But the vast majority of the folks that I've talked to, once we've talked it through and we've looked at it, they've said, aha, it makes sense. I get it now. This is so clean and this is so easy. It's just been a week of education. And I think we need to just do a lot more education because it is clean. And I also think separately, because somebody said something about we just need to make it easy. And we do, it needs to be easy. But realtors need to be competent, licensees need to be competent, folks it's not just Trek rule that we're competent, but it's code of ethics that we're competent for the realtors. At the end of the day, they need to come take the training. They need to learn how to fill out the contract documents, because this is the most important thing in all of the pieces that they do in their real estate business, and they need to come and learn it. And I think it will make a whole lot of sense. I think it's clean and it's easy and it's right there in the contract.
Diane?
Yes, I agree with Melissa and Christy, so I won't repeat anything that they said because I totally do agree with that. I created some CE Trek approved 1 hour, 3 hour contract change courses that began in December. And every one of those classes that I have done, I've asked them what they think about the contract changes. And I'm repeatedly getting a thank you for what we did in paragraph 12. Those who really understand are saying you made it so much easier. When the form that they had to use, which is no longer there, and it was explained by David Jones and Robin in training they did for the Texas Realtors faculty, that form recreated forms that were already provided by Trek, and they couldn't continue to use it for that reason. Therefore, they were just going to get rid of it in total. Agents spent a lot of time learning a very complicated form, in my opinion. It's now gone, and they're looking at just paragraph 12 and paragraph at the bottom of page 10, and they're getting it. It is taking the training. What they were misusing, and for the very basic reason, is that agents are feeling that they have no place to go to know if they're going to be compensated or not. Not every agent is going to fill out the compensation agreement between brokers. They'll not return a phone call. So it is an adjustment period where agents writing an offer don't know if they're going to be compensated or not. So they have to create the offer. What they were doing is misusing or maybe using in a different way as part of negotiations, paragraph 12A1, where the seller was to contribute to the buyer's compensation to their brokerage. The bottom line is that I think will be the answer, in addition to education, is what we already have living in the farm and ranch contract with some tweaking. What are they asking for? The A is a license holder in general. They want to know, and the consumers have a right to know as well, big picture, who represents who is paying the listing broker, who is paying the buyer's broker, and how much. The ratification of fee on the farm and ranch contract has the signature of the listing broker and the buyer broker. And at the bottom, it has the signature of the buyer and the seller acknowledging who of those principals are paying which of those agents, if at all, and if so, how much. That is a page that I think we owe it to the consumer and to the agents to have their signatures there saying, I know I am getting X percentage from the other broker. And I know that I am the principal and I am paying or I'm not paying for the services of the real estate professional. It's there. It's worked in farm and ranch. Many of those comments we got way back when were saying, please give us the farm and ranch. I think we need to look at that seriously when we look at moving forward. The agents want something that is going to say to them all in one package, this is what the agreement of parties are, and not part of the contract necessarily, but on the page like there is in farm and ranch. That's what I've heard.
And it was a lot of discussion in our prior meetings on the farm and ranch, and it was really close. We look at the votes that came in terms of numbers. That was probably the most requested one. Tempered by, not to rehash everything, but tempered by confidentiality. Why should I disclose on the listing side how much I'm getting paid? And the lawsuit wise, does that then throw it up and out in the open to be at this discussion that was concerned about where everybody then starts standardizing. A deal doesn't go through. Well, now you know what the listing agent's being paid, and others will know. And I think I agree with the sentiment. It's a lot of education right now to see. There is a definite thirst for wanting it in one place to understand all the numbers. I think title will say the same of wanting to know at the end. I've heard some say, well, we'll just get the CDA like usual, and other ways. The lenders are raising issues on requiring to see those agreements anyways in a lot of cases, not under law, but just under underwriting procedures. A lot of these things that will shake out. SJ, did you want to add your comments on the farm and ranch?
I was just pointing out that it isn't all exactly on one page in the farm and ranch. The ratification of fee is just the ratification of the listing broker's fee going to the, whatever they are going to be called, the procuring, or buyer's broker. So we don't have everything out there for them. Like, if the buyer is going to pay some directly, maybe we want that. Maybe people want that, but it's not there now.
How much has Track Education Committee picked up any of this for what they're going to do for agents, brokers?
There hasn't been any, so we do have an Education Standards Advisory Committee, and they really haven't touched these issues. However, this will be, I think, in broker responsibility.
We're doing it right. Like in this moment, as I'm like, 3:27, John says something really helpful. So like we're very aware and working on it, and like we're planning to take
John,
it.
3:27.
That's what I was going to say. But the other reason is we have Sierra Pizarro here who this to hopefully push out, because I think content like this is
Yeah, I mean,
helpful.
the education piece is definitely huge. That's probably the number one conversation I'm having, 10 times a day. I'm sure you're having the same things. And it's requiring that agents and title, and to some extent consumers, extrapolate from multiple different places. The contract specifically doesn't provide anything about if there's over and above what the seller's paying that the buyer is obligated to pay. And so we're completely in the dark, and, we oftentimes on the title side don't find out at all until we put a statement out and it's wrong. So I think it makes it harder on the consumer when it's not all in one place. So I agree. We're too early to make another change.
If you look, this has gotten popular in this area, and it's only because it's unlocked MLS. So it's the big MLS in this area. And that's the disclosure right there. That's telling who's paying what. And this has gotten popular. Everybody's using it. If they're a member of, I'm not sure if they everybody, a lot of agents are using it if they have unlocked MLS.
And from a consumer standpoint, that's their last ditch effort to say, wait, now I understand what's going on in the transaction, and I'm not comfortable with it, or I am comfortable with it, or I want to try to renegotiate it. But we're seeing that very inconsistently used.
What is the form that you're waiving?
It basically is an addendum. It was in one of your remarks. I think Abby sent it in just this morning, right? It was in one of the later remarks.
From yesterday.
From yesterday.
Supplement.
It's in there in the supplement, and it looks basically the seller's broker, AK listing broker, will pay this. The buyer will pay this. I mean, it was very simple, and they have it for leases and for sales.
Well, isn't that what we're talking about on the farm and ranch contract? And I misspoke. It's not everything on one page, because I don't think it's necessary to ask what the listing agent is paying. I'm just simply saying, going back to what was just spoken earlier, is that we were one vote away from just carrying over the information that is on and remains on contract. If it's good enough for the farm and ranch contract, then it should be good enough for all the contracts. Now, maybe moving forward, we'll tweak it, but I think that if we've got it, if it's worked for years, and it gives what the agents are saying they don't have a clear understanding of, meaning is how much is the buyer's agent going to be compensated for, which ratification of fee covers. At the bottom of the contract, it is signed by the buyer and the seller, just acknowledging again what they are agreeing to compensate. The issue is compensation for all parties, the principals and the agents. And all they're asking for is something with signatures. And we have it. So why don't we give it to them?
But Diane, so paragraph 12 of farm and ranch is the same essentially as paragraph 12 or the equivalent of other contracts. But the whole situation about the brokers signing is still only related to the brokers sharing of fees because historically, traditionally, that's how ranch brokerage has occurred. The agreement has almost always wound up on the contract. But those broker signatures are only for the ratification of the fee between those two and those two only, and they don't become a party to the contract. We actually had changed this several years ago to make it clear that they're signing only to talk about the fees between those two, the ratification of fee. So they don't become a party to the contract. They're not a party to paragraph 12, and the clients, the consumers, the buyer and seller are just acknowledging on that portion, on the ratification, they're just acknowledging that the brokers are sharing some fees, but it doesn't morph into now a four-way contract between two brokers and two principals or more.
So let me throw that one of the solutions or possibilities to throw out here that addresses some of the comments that were made of not understanding a couple of different things, but going to the ratification of fee, right? If you paragraph 10 or page 10 right now, is that something that we can have a ratification like the farm and ranch down there with additional language that says this amount is in addition to any amount agreed to in paragraph 12, or I would say it's actually the reverse, because you have an enforceable agreement and paragraph 12 says I'm paying this amount more to the extent the buyers agree to pay it, right? And so we had that limitation, and I want to bring up a potential concern with that buyers agreed to pay language as well. So I don't want to get lost on that, but as one of the solutions below the signatures on a clearly separate page with additional language, could we have that ratification and add a tagline to make it clear that it's in addition to, or the base and 12 it on, without having a
absolutely.
If Lee was here, she would say, don't get it anywhere in the contract and don't have that bottom of the farm and ranch where they're agreeing to make additional compensation agreements in the contract itself. So maybe the ratification's an intermediate ground and we draft around to make sure we don't intend agents to be parties.
Absolutely. I love this unlock form, and I would prefer, and I'd suggest that the direction we go is we keep in the 1 to 4, we keep the broker information page, except we take out that disclosure, and then the next page would be a confirmation and ratification of commissions along the lines of this addendum. And we would have the brokers sign, the buyer seller sign it along with the brokers. And this form does have a statement that says, by signing this, the brokers are not otherwise a party to the sales contract. And I think that's a clean, simple solution. I like that.
Yeah.
We're going back. I mean, I'm not saying it's bad, but when
we're going back to farm and ranch.
Well, no, we're going back to a standalone form is what you're talking about, but you just want it embedded.
It's embedded. Yeah. Yeah.
Well, and but we're
mandatory standalone
here, right? And so we were very close to furthering the discussion on farm and ranch, very close to continuing that. There's a big desire there. And we always said what we did is the first step in that we're going to continue to look at it. Again, today being 7 days in, we're early, right? But this type of discussion, so when we come back next meeting with more feedback, I think teeing this up for other thoughts is a good thing. And that may marry the having it disclosed and signed off on, but limiting liability on agents. So make sure they're not parties to it. And that may be the middle ground of a next phase 2 step, or maybe not. But I like the discussion, and I don't think it's contradicting having a separate form versus at the end and something to consider. I want to, Melissa, your hands up before I go on.
I was just going to say, one of the other comments somewhere farther down that we haven't gotten to yet, though, I think it came from Texas Realtors that said, okay, wait a minute. On farm and ranch, if we put information in paragraph 12, what does that do to the bottom of that farm and ranch contract? And there was a specific example with some percentages in there and stuff. I think I think that we need to consider that as well instead of, because the conversation was kind of like, well, maybe we should just kind of go back to adding in what the farm and ranch had. But I think that that still doesn't work with paragraph 12 because there's still confusion in the marketplace. That was all I was kind of trying to get at.
So SJ, on paragraph, paragraph 12, and if they sign that number there, this is a little different from the 1-4 context we talked about. And they also sign the agreement to pay brokerage fees at the bottom, which the seller agrees to pay a separate amount there. That's, I think, the situation that's being teed up, at least partially in what Melissa said.
Well, I've got a response to all of the comments that say, well, what if they basically say, what if the people can't do math? What if agents make an error? Well, the answer is don't make an error. Okay? Check your work. I mean, we can't make a form to fix that. And I'm being very serious. It is funny, but I'm also being very serious. You know, you've got a damn license and you've had a lot of training to be able to have that license. This is a professional and you're getting paid good money, you know, to do this kind of a job. You know, the licensing statute essentially allows y'all to practice a little bit of law, but you have to do it right. So, you know, some of this is just getting used to it, but, you know, don't make errors, just like you don't want to make errors elsewhere. That's really what I have to say to a lot of this.
I would tee up that the farm and ranch is a little more nuanced than A plus B, because in paragraph 12, the sellers make an agreement to contribute X. And then at the bottom, they're making a separate agreement potentially with the language to contribute X. And it says don't sign if there's another separate agreement for payment of broker's fees. And so if they're signing in 12 or putting in 12 and at the bottom there.
It's a double
And so is that really an addition?
You know, we can maybe clarify other than the one above or whatever, something like that to clarify.
Or
Point well taken on the other.
put that line on 12 into the contract or something that the buyer and seller understand that there's a separate agreement and it's being acknowledged and signed by the buyer and seller. All I'm saying is page 10 is outside the contract. It is outside the contract and 2402, buyer and seller aren't signing. No one's signing that form. That's what my hang up is. And if we get a buyer and seller to acknowledge, I have no problem. Then we're okay. But they have, just like the farm and ranch, we've acknowledged it's an outside agreement. Done.
But the beauty of that, which has worked for the farm and ranch practitioners, is although you are legally corrected, and we have worked hard to make sure that it is outside of the actual contract between the buyer and seller, it is in the form.
And they're signing.
And they're not having to go get the form and figure out, is this the time we use it or whatnot, which I think is why we eventually got back to let's embed this across the board in 12, instead of having a form. That's what I think I recall about the ultimate, here we are at our first step to put it out there.
And that's how I was. I didn't think we were going to have a form. Everything was going to be embedded in 12, but that's not what's happening.
Our public members here to speak on this topic.
I was with him. I knew that's where we were going, but that's not where we went.
Do you have any particular thoughts? And you're muted as well, but any particular thoughts on this in terms of looking at it from the public perspective outside the lawyers and the brokers here?
As simple as possible, but I agree with SJ. I mean, just don't make a mistake. So I kind of like it being in the contract. I've not gotten any feedback from staff yet if they're having any issues with this. It's only been 7 days, so. But I like having it in the contract. I think that's.
Brian, how is title interpreting 12 and because they don't see 2402. So how are they interpreting all this?
They're not understanding it. And again, it's new. Again, I had a 25-30 minute discussion with some people yesterday about how you put it onto the settlement statement and what does it mean and what's the difference between paragraph 12 and the page 10 disclosure. And at the end of the discussion, the light bulb did go off. The confusion that I've heard in classes that I've done, the confusion is this in 12A1B, where they talk about apply to brokerage fees that buyer has agreed to pay. And they're saying, well, wait a second, this is what seller's agreeing to pay. And they don't get the connection that this is just like the old way where seller agrees to pay amounts that the buyer was otherwise obligated to pay, like the fees that they have to pay to their lender. So, I mean, yes, there obviously is, one, you got to educate, two, don't make mistakes. But number three, having everything in one place, and, I like the idea of having that page at the end that pulls it's like the rug really pulls the room together. Have something at the end that everyone can sign that says we acknowledge that that's what this is, and this this form that we have does that, and you can cross-reference paragraph 12 into the separate page. But I think that will make a difference, and we got to remember that the public has to understand this, not just the agents, but the public has to. And I think that, and that's essentially the same thing that's going on with Farm and Ranch. I think having it as the back page on the 1 to 4 makes sense to me.
To answer your question, Mary, from a practical standpoint, the only thing that works is calling both agents in the transaction right now and saying, what are we supposed to be putting on the statement here? Because everybody's doing it differently and everybody's doing it wrong. So that's just the only thing we could do right now.
And that's not bad.
Well,
I mean, is
it's
that
not bad, but that wasn't the point
Right.
to call both agents.
That's what has to happen now.
And when we look at this language further about cross-referencing, if we end up putting something at the end or adding to 12, one of the issues with clarity is, what does that exactly mean? And is there a short tagline we can add to it of that buyer has agreed to pay, such as in their buyer representation agreement, wouldn't be such as, but some additional tagline that could be limited and not extend this contract really long to provide some additional clarity there, whatever's ultimately needed. And with that practice, we've addressed some of the rule changes that practically will have an impact on the industry that then have an impact on our forms, right? That at least those that are members, are realtors, members of National Association of Realtors, have to have that agreement for the buyer to agree that that amount can be paid. And so that's what we addressed there. There's the first comment we have here wants to go further and say, get rid of that and do a lump sum for all seller contributions. We've talked through that in the past, but we can see if more comments come on that. We can go through these comments here. I suggest we may take our lunch break and then come back and march through the comments. And I one thing to clarify with Robin during the break that may truncate my next thing I would like to tee up. But I think, as far as today's actions, I am hearing a lot on this more disclosure somewhere else. And maybe that's that step 2 we always talked about may happen. And we can, look at this, a compensation subcommittee, which is still active, maybe come with some recommendations on how that would look, and in terms of if we did it on page 10 as part of the same form, or, we can take what we've already done in the past and just add to it with the knowledge we have now on how to do it. So maybe that's a way to talk this out, but at the same time, advance the ball forward and address it when we have the boots on the ground data at our June meeting. But thoughts on taking a quick lunch break, but taking a lunch break and then coming back to address the comments that were submitted today, and then advance the ball that way.
I concur.
Do it.
Okay, so we'll break for lunch here. It is 12:14 now. Do we want to say come back at 20, 30 minutes? 30 minutes? So we'll come back at 12:45. Okay. We're going to pick up now and walk through the comments that were submitted. We're on agenda item number 8, and I'm starting on page 13 of the materials. And several of these issues we've already discussed. I want to make sure we didn't miss any in terms of the compensation. And there's non-compensation items that are mixed in here that we can spend additional time on. Starting with Todd Franklin's comment, he would like to see one lump sum amount in paragraph 12. So we don't make the differentiation between compensation and other seller contributions. And he also thinks by doing it that way, the compliance could be done by the lender, like the lender looking into the amounts. And there's an issue right now of who's policing this, who's policing that the amounts are actually agreed to be paid by buyer and other concerns. So that was his comment to us. And feel free to stop me if you have comments on these. I'm going to march through and just say them out loud in case it stirs something. Lynn LeBird, excuse me, wants page 10, sorry, to the group there, wants page 10 disclosure to be removed. And she wants thinks agents wrongly believe it guarantees payment. Title companies are starting to demand copies of representation agreements and highlights that they don't rely on page 10 either. So it's another reason to take it out of the contracts. And this is definitely something we've considered. At our last meeting, we had a pretty strong discussion about removing all compensation from the agreements, including that disclosure. So we'll keep that in mind as these contracts become more utilized and see if that confusion continues. But just so everybody knows, it does say this is informational only, right? It doesn't change anything. It absolutely is informational only. The separate agreement controls. Looking at Indra Elliott's comments, she wants and questions the language of paragraph 12 and page 10. And what she says that page 10 refers to an amount to pay the buyer's broker, refers to a separate agreement between the listing agent and seller. And that's not true. It's not between the listing agent and the seller. It's actually between brokers. So if you look at that from the general forms of the CABB or 2402, that's what page 10 is meant to be, broker to broker. This doesn't involve the parties' agreement between their broker or the other broker itself. And I think this is a common sentiment about will not complete both. And can't read my own notes here. And seller intends to pay both, right? So remember, 12 in what the amount that's represented by the page 10 disclosure are stacked on each other, two separate amounts that you add together. Linda Escalante wants page 10 removed as well. Questions contribution versus cooperative compensation. Would like a clarification on 12A1A2. This was another common issue that's been brought up on 12A1A. Says the seller agrees to pay the brokerage fees that seller has agreed to pay. And to tee up the confusion here, which is a little different than we talked about, is, well, the seller's agreeing to pay the cooperative compensation through their listing agreement. Right? They're paying and funding whatever amount the brokers agree upon, broker to broker. So is that then duplicating the amounts? Is the seller agreeing to pay both in A and B the same, right? A through their listing and B another amount on top of it, or the 24/2. It's that same confusion. What's meant by 12A1A is the amount that the seller is paying out of their pocket through to their own agent, or the fees that they're agreeing to pay. 12A1B is paying to the other side. And so if you're looking at that, those are two separate amounts, two separate payers in terms of the, same payer, but two separate amounts that are stacked on each other. C is the other contributions. But does anybody else see, and I'm not teeing this one up particularly well right now, I definitely said it much more clear, this issue with paragraph 12A1A in its interaction with the other language that we have. Has anybody else maybe can better articulate that concern than I just did, or share the same concern? And I would also tee this up to the visitors here that have talked about this a lot. Is this a 12A1A? I would ask the group over this.
Rubies. So I've heard her say this. And I think we wrote in one time, the last time we sent you a comment on 12A1A that people have a tough time understanding, getting clarification. And I know RDR realtors don't read, or agents don't read, or they don't comprehend, but 12 just is beating them up.
So it's another general confusion thing that we'll see how it plays out. Let's see, is this in questions again, whether it's in addition to or not, is this in addition to the fees stated in the listing agreement, which may or may not include buyer's brokerage fees? And again, no, that's separate. 2402 versus a seller contribution, broker versus seller paying directly. Jeremy Reed writes in, and his question is, how does a buyer broker know when to properly fill out that section, meaning 12A1B, to present an offer when the buyer broker is not privy to the exclusive right to sell agreement? Is this placing an additional obligation on the seller, or is this more a notification that seller's already agreed to pay in his or her listing agreement some other amount? Again, it's what's established. It's what's established in there, the firm agreement to pay, and the buyer will know that on there they're getting this contribution amount. And the buyer should know the amount that their broker's already agreed to have contribution to cover part of what they have to pay. So keeping those two different amounts separate, I think, answers many of those questions like that.
Can I ask sort of an overview question here? Everybody's comments came in on Form 20-17. But weren't they actually commenting on what has now become 20-18? Is that correct?
Yes, that's the new version, but they may be looking at the red line, which
Of
was kind of the
17,
old-
which was, okay, but they're the same,
Yeah.
right? So 17's red line is the
Yeah.
effective 1/3/25,
20-18 is the
18.
correct.
Okay, because was looking at the 18 and I'm
Yeah.
thinking, oh, wait. Yeah.
And then Mr. Reed also includes what is a Texas Association of Realtors form there, the listing agreement on 101. So again, for clarity purposes, we have no, that's not our form. We don't have any ability to change it. And so
We don't have our own, right?
Exactly. We do not have as the Texas Real Estate Commission, and this committee has never recommended a buyer representation form or a listing agreement form. And so there's various reasons for that we've gone through at length, but so these forms that are the listing agreement, buyer rep agreements, we can't change as much as we may have individual feelings would like to. Those are. And I will give credit to both the Texas Realtors and others this is a complicated issue and they don't have the benefit of time like we do on this committee. You know, we have to follow the law. We have publication requirements. We have things that by law slow us down, that we can't run any faster. Them being trade associations and brokers dealing in the field, they have to move fast and deal with the lawsuits and implications of it in ways that are by necessity quick. And so in drafting these forms, I do give them credit for moving fast in the job that they do. It's not easy for sure. Sarah Townsend says, can both 2402 and 12 be used in our amounts added together, or better to amend the listing agreement and just use the 2402? And as we've gone over again, they can be used together and stacked on each other.
Did you skip Michelle Lorette?
Did I? I did. Michelle. So I'm not sure I understood Michelle Lorette's question.
One line for both.
I can help because I keep seeing it over and over again. What folks are asking is if we're going to put under 12A 1B for the seller to pay money, why can't we have 12A 2 for the buyer to pay money towards the seller's obligation to pay their agent, right? Like if we were in a crazy market, like we saw several years ago, would it be prudent for a buyer to say, I'll pay all of my agent's fees and I'll pay some of yours, Mr. Seller, and to make that as part of their offer?
Which is available in the farm and ranch. If we want to play, show what's in there, the buyer can agree in the bottom of the farm ranch contract to do that. So it's not an out of left field request. I'm not sure that's something we would, think about right now in the 1-to-4 contract in terms of the practice and that being a very, very small percentage. And I tease that to brokers that if you have experience otherwise, but that's such a small percentage. I'm not sure we need to cloud the.
Yeah, and keep in mind, John, the reason you would have the seller paying broker's fees of the buyer is because the buyer may want to be able to roll that into their loan, but on the flip side, they could just increase the sales price.
That's a good point, and that's how. Well, I won't go down that bunny trail, but yeah, very good point there. Looking at, did I go through Mark West? Questions how to list?
No, you're at Mark.
Okay, so Mark West questions how to list the amounts in 12 and page 10, and saying if 12A1 A1B is marked and that the seller puts X dollars towards broker's fee, should pay page 10 of the contract under disclosure also be marked in. Those are two separate amounts. So if you're intending to pay only the amount in paragraph 12, then you shouldn't put anything in or NA in the disclosure on page 10 because nothing has agreed to be paid there. But if you do have an enforceable 2402, the broker to broker compensation, that's what should be listed on page 10.
So as a true lawyer, John is saying it depends.
Depends. And this is where I love this. My wife, Erica George, is in attendance today and has started practicing law. Lawyers can get real lawyerly quick. And we start going down bunny trails that just get confusing and kick me in the butt, say, just get the deal closed. Tell me what it means. And so that's what, again, the magic of this committee is to help keep us lawyers in check so we don't get too wordy.
Is that what it is?
I think so.
Hey, but this is a good example of the confusion.
Yes.
A super example.
Yeah. So it truly, in answer to the guy's question, it really is, it depends. It depends on what the parties want to do.
Well, and this is where a simple sentence as we're one thing that's on the table of including this does not include or is in addition to any amount that's in 12 or vice versa, of having some additional parenthetical that's short to cross-reference and to clarify. And I do think that's regardless what we do next time, if it's the full,
right,
adding to the contract, all the stuff or addendum, I think that is something we absolutely should look at doing just to tie the dots together. So Scott Culberson wants, this is a non-compensation issue, wants increased transparency regarding the escrow agent. And it points out now that we have a defined term escrow agent. Before we had the lowercase e and a, and now it's defined. That's a defined term, but it doesn't think the public understands what or who the escrow agent is. And this is one thing that I think we admit on this committee is filled out wrong a lot in the contract.
Yes.
The escrow agent's meant to be the organization, or if it happens to be an individual, very rarely, that's holding the money. And as a practice, agents write in the escrow officer that they want to handle the transaction.
Or the closer. Or even the closer.
Yeah, the closer, the escrow officer, the closer that closes the deal to make sure file at the title company that they use. But we've also recognized it hasn't caused a problem, right? And it is something that, even though it's misunderstood, hasn't risen to be a big issue that's creating liability out there. And but we always, when this is brought up every other meeting or so, look at it. And I don't think that's changed. I haven't seen that general perspective or situation change, particularly after we capitalize escrow agent. But the point is very well taken that it is confusing to a lot and often misused.
But he wants us to add write in the definition.
To write in the definition of what an escrow agent
agent
actually is.
So that they could fill in the form, right?
Correct. And he goes a step further too, to say that, or suggest that we should have a definition page added to the end. And then we take all the defined terms and, similar to a critical date list, have it a separate, page at the end that goes through all the actual definitions. And this is one where if this was lawyers and we didn't care how long the contract was, we could expand on it. And that's somewhat why we had the 5% rule, right? Of make sure these aren't too long and 100-page contracts. And why certain things we know may not be utilized correctly, we don't see creating issues and don't change. So does anybody have in light of this comment, any changed opinion on that, or see a need to do anything further at this time? Okay, so we'll move on to Lawrence Henry's comment, which if we did, it's a definition of holiday. I have that. Rhonda Lowe wants to, this is a different comment too from compensation, wants to include language about the expiration of a contract if the seller doesn't respond. And she points to an example from the Indiana forms that has that. And I'll tell you, this was asked at least in one of our broker responsibility training sessions that we did, and in one of those sessions as well. And it's a fair request. And I think the concern here is, as buyers, we submit these offers out there that are open-ended, right? They don't have a cutoff date, an expiration date. And so how do I have to rely on my agent to say we revoke our offer, it's no longer active, to make sure it doesn't stand out there and our consumers being put at risk by agents that aren't on top of things. And all of a sudden, 2 weeks later, you get an offer back that the seller says, I accept and sign, even though you've already made an offer and had it accepted on another house.
Do they resubmit when they go past the specified time?
Right, yeah. If they're still wanting to.
Yeah, they still want it, they would have to
It says it's no, it says it's null and void. So that's the problem with that.
We've talked about this before and had the lawyerly discussion of, what is a reasonable time if there's not a time put in there. And just to be clear, there is no requirement for an offer to have an expiration. This is, if they want it to have an expiration, they need to add it in there. But, the law has defined it through some cases as squishy, and we'd probably all say 30 days. I don't know if this is really a solution looking for a problem, or,
The only benefit, I think, to adding it would be that we still see agents language to put in there to accomplish that goal.
Again.
I know, but
yeah,
it will solve for that.
Yeah.
Brokers, have y'all experienced this? Is this a big problem, or is this a 1%er? How do you see this?
Sorry, you go ahead, Melissa. I didn't raise my hand.
Oh, I was just going to say, I don't see it as a big issue. We don't have a lot of it, but what I do see is that sometimes people will just write it into special provisions, right? Because if they do want to have that, they just write it in, and then, people are saying, I hear agents say, or brokers say, well, it was just an offer, so it wasn't enforceable, so they can't tell me that it is or isn't any good. And, people are just writing whatever they want. I know we try to discourage them from writing in special provisions. So for whatever that's.
I very much agree with Melissa that it's not a huge deal. I know what we teach, and I know every brokerage can be different, but TXR does have the notice of withdrawal of offer. And so we always tell our agents, hey, if y'all are moving on, please make sure we don't leave an open-ended offer out there. And I can see, even if we put language in there to have a time frame, some agents are going to fill it out and it's still going to be unused. And I still think at the end of the day, it's an education thing. And I know not everyone's a member of Texas Realtors, but I just think they need to even send an email and say, we're withdrawing our offer. My client withdraws their offer. That's just, to me, a lot of an education piece.
I agree with Christy. I think that's where the issue comes in, is when they put an offer out and they don't know if it's been responded to, how do they withdraw it so they can move on to something else? Based on that, there may be some validity. Oftentimes see it when they see a contract from another, I believe Arizona, from another state that has those dates in it. And they say, what a great idea. Then you know how much time you have to respond. So it's some validity, but I don't think it's enough of an issue to change the contract for it.
And she also adds, Rhonda Lowe adds another Indiana form that has seller's response to the offer to make it clear that the offer is accepted, rejected, or a counter offer is submitted with it. Because I feel that kind of leads to the same thing we've already discussed with we just discussed with the expiration of the offer, but likewise TF that suggestion. That's I don't think we've had that particular one recently to the committee.
We haven't had it to the committee. I've had it as a lawyer. The questions come to me twice since we've met. The last time about, somebody complaining they can't get a response, or that they don't believe, even when they were told by the other broker that it was submitted. And I just don't think there's some things that we can't fix with a form. No, that's just behavior.
I think it's solving for the 1% because most agents are going to present it and have some back and forth. It very rarely just goes into the abyss.
Does Texas Realtors have something that addresses that?
We do have, I was mentioned before, we have the notice of withdrawal of offer.
Okay, yeah.
So that form is available to members. They can, if they're done waiting and they just send that in. We don't have anything that's, similar to this.
Have you submitted my offer?
And we do have the rule that they have to respond within 2 calendar days to the other side, not business days, but calendar days. It doesn't have to be a response to the offer, just acknowledging receipt of it. And if for those agents that aren't presenting it without written instructions from their clients not to in whatever situation, that's definitely a fiduciary duty issues at the end of the day that can have their license at risk. So there's ways to police it at the end. But the frustration when you submit an offer and you don't get a response back, that's a frustrating situation. But I think it falls within that 5% or 1% bucket at the end of the day.
I think it does too, but I also I want to throw out there, I don't think that this form would solve the concern that folks have, because this form says they've accepted it, rejected it, or made a counter offer. And that's not what the question is. The question generally is, did you even give it to the seller? That's more of like a acknowledgement of receipt as opposed to accepted or rejected or countered, because sometimes the seller may not want to accept or reject it just yet. They're waiting to see if another offer's coming or whatever's going on. They can still say, I got your offer. Thanks for asking. So I'm not sure that this is the right form regardless.
Well, that is a good point.
That is.
And the other thing that I, at least with some of the clients I'm dealing with, they are happy to put parameters on what they want. They don't want to see junky offers, and maybe the offerer just can't acknowledge that they have a junky offer.
And some of that is highlighted by the market that we're in too. Right. We're in that hot market of a couple of years ago, and you're getting 50 offers in on a house. Right. It's that creates a situation that makes it difficult, and it's reasonable for sellers to set maybe some bounds around what is actually presented. Okay, so we'll move on to Carrie Tuggle's comment. She doesn't think that compensation should be in paragraph 12. Would like to see it with a disclosure at the end with the cooperative compensation disclosure. So we're looking into that for our next meeting, and we'll address that further.
May I ask a question? On the bottom of page 10, is the history of no initials on that page from buyer and seller, just acknowledging the information included. I'm sure that there's a reason. So I get that question. I'd like to know from the attorneys on the committee why there is no initial on the bottom of the broker information page.
From when this predates it's on 2017, or I think it's when I was on the committee, or I forgot when I was actually first appointed. It predates that. So I don't have the institutional knowledge, which maybe Ron has on here. We're never going to let him go because we're going to lose so much of that. He doesn't know that yet. But so I don't know, Ron, if you have any insight to that. I have some things that have happened afterwards, but
yeah, no, I think you hit it. I think it was that this is many times, sometimes the information was provided after the contract was already signed. And so it's like, especially on the receipts. And so I think everything after the signature line is just doesn't matter.
I think I remember, since we didn't have it recorded, nobody can prove it if it's not true. But I think when we took off the compensation off of the 1-to-4s and related, just left it on the farm and ranch, we had a discussion that this is not a page of the contract. It's not a page of the contract. So the buyer and seller don't need to initial it because they're not a party to, this isn't, actually 10 isn't even a contract. It's just a notice, really. So we took it off if it was there. And I think it was there. Maybe Amy, if Amy's still there, she might remember or Brian from 2012, but
I don't remember. Your memory is better than mine on that. Sorry. That sounds feasible though.
I seem to recall that we wanted to make it really clear that it was not a part of the contract.
That's what I thought.
Yeah.
Thank you.
We'll go on to Brian Collette's comment. Wants a provision added to the buyer's temporary lease to address adverse possession situations. And he specifically points to paragraph 18, which is the termination paragraph in the buyer's temporary lease. And it doesn't have a definite date. It's tied to certain events occurring, like the closing that would happen, or a breach of the agreement, I believe. I think this is a 1% issue, and it's highlighted by the fact of how long the concern, I think, is limited as well, because how long the adverse possession statutes are. In Texas, there's a 3, 5, 10, and 25-year statute that's tied to different things. And the short time period that these temporary residential leases are in place, get nowhere close to that. Holding it for the short period of time that they're intended for, I don't think have a material impact on the. It definitely not broad enough to go over 5% or.
Right. And just on that, as a reminder to everyone out there that we even have it at the top of the buyer's temporary residential lease form. This is only for 90 days at the max. And I can't remember what statute. There's some reason specifically that we do that.
Additional requirements kick in if you have to lease over 90 days.
For disclosures. So, I mean, the guidance would be, if you think, first of all, I think these are a terrible idea in almost 99.9% of the situations, but get your lawyer involved if you're going to be doing this, right?
And this is where I was like, there are contract for you, be careful for lease purchases.
That's
and
right.
Using this for longer than it's intended,
That's
because
right.
once you get past 179 days, you're in some potentially very hot water. And a lot of different concerns are raised with executory contracts, or as we used to know, contracts for deed. So be very careful on that. The next one from Craig Smizer, I believe is how you pronounce that. Asked for Trek's help in getting an update to the seller's disclosure notice. Believes that there's no options for water districts in there. And I think this is I maybe confirm this for you, but we do have MUDs listed in there, right? The seller's disclosure notice, which is one we don't change out of the 5AA of the property code, at least as of now. Actually lists MUDs, which in MUD is a water district would be included as the MUD. Right, so that.
We do. I had looked up water just a minute ago.
And we always say the mud form, right? The water district forms kind of general language. And in fact, our paragraph 6 changes. We switched that up, right? To not just use mud, but to be a more broader definition. So a couple of things. One, I think that's already in there, and that's straight out of statute. Says the statute uses mud.
Well, it says water.
City well mud co-op.
It's one of the check boxes under the
page 1 of the seller's disclosure.
Okay. It's also more on page 5 or 4.
Yeah, so right there.
Yeah.
So we're on.
It does have mud and co-op.
And so I think this may be a misunderstanding and highlights the confusion on water districts and MUDs and what qualifies or what is what in that phrase on there. But it is listed. A water district is a MUD.
And then it also, again, towards the end on page 4, groundwater conservation district or subsidence district, if we're in there as well.
And so his thought was that water districts weren't listed and wanted it to be added. So a couple of reasons why is one, it's already in there, and two, it's a legislative issue as we've at least historically addressed it. Going on to Angela Choa's comment, this is in regards to the backup addendum. And we have discussed this at the last meeting as well, but she would like to have a notice of termination of the first contract. And require a couple of things on that is, so our backup contract operates where a buyer submits a contract, but the seller's already under contract with somebody else, but they can accept it to say, I'll accept your offer as a backup for this second buyer. And the backup goes, what we generally say is in the first place at the time that the second buyer receives notification that the first contract was terminated. There's a question on a couple fold of what type of notification needs to be provided. And a lot think, well, just an oral notification is fine, or does it need to be in writing? And what do we need to say? I would say on the written versus oral that our contracts require notices in paragraph 21 to be in writing. So that notification needs to be in writing, doesn't need to be oral. You need to follow 21, paragraph 21 of the contract for that. But I think we can, and I do like the idea, and we have our backup subcommittee that with this, I think it's a good idea to have a notice of termination form to make it clear. It could be very simple, and I think track just with a sentence or two or some of our other forms, have it be very clear. And why it's important is because the deadlines in the backup contract run from that date the written notification is provided. And that's when the amended effective date of that backup contract comes into being.
The realtors have a form for that purpose.
Yeah.
Texas, but looking at beyond realtors.
No, I know,
the
but I'm
general.
saying you could use if you were to adopt that form, I'm sure the realtors would then pull the form down. So that would be one that could be stolen from them.
Yeah. And so any opposition to doing that, to having our own form for that purpose? It's another form, but
well, now it's a notice, right? So are we
getting in the business?
Get in the business of doing notices, but as the contracts are done beyond just the form or not. So now I know we've got mandatory like seller's disclosure notices and other notices that we're looking at. But in terms of communications between things in the contract, are we going down a route we want to go?
And I'm not sure the slippery slope. I'm trying to think of other ones that would be as stark as this that would
we'll give notice of termination.
Mm-hmm.
Right. And so other than notice of termination, do we give other notices?
Not provided as a form, but then what would the notices that we would start bleeding into that would be similar to the simplicity of this? Because most of that, we have a lot of notice tied into notice of termination from various paragraphs that
objections is the one I'm thinking. What other notices do you
There's a landlord's floodplain notice, which is essentially statutory. Notice to prospective buyer.
Notice
In
of
it.
termination of contract.
Utility district.
I'm not sure if there's any similar notices that we don't provide.
Special taxing or assessment district.
Well, you have to give, I mean, there are a lot of
Inspection
things,
record.
there's a lot of things you would do, like notice of default, notice of requesting
Subdivision.
mediation.
Subdivision.
They have the backup addendum, probably have some stuff under the contingency addendum. Right.
Okay.
That one has an automatic termination or the sale of other properties.
Yeah, that's the one.
Yeah, that has our only automatic termination provision in there. So there's no notice needed. It just automatically terminates if it's not.
Yes.
Yeah, I thought there was, that might be reason to give notice. I mean, how else are you going to know?
Well,
How else
there's-
is the buyer going to know
yeah.
that the person is terminated?
Coastal area property, it says addendum, but it's really
If
a
I can't
notice.
sell my other property, how do I get notice that it's terminated?
Propane gas.
I think this one, and to you, this all up for discussion, Diana, I see your hand up. It's something that's a pretty very important date that is distinguished from some of like the title objections are, we can never cracked title objection notice, right? That's so, there's so many trails and it's every case dependent. This is a very black and white issue. And it's so important to then establish what the amended effective date is. So, you know, the deadlines by having that form or by having that proper notice. But Diane, if you want to.
And that was going to be my point. We rely, because we are realtors and not everyone a license holder is, the Texas Realtors form for communication purposes. And I think that's the point we're talking about right now. In order to give notice that the buyer is not going to move forward and is withdrawing from the backup contract, they have to determine how they're going to give notice. So to have that piece, that communication piece as part of it, I think would be providing a service to the consumer and to the agent. And I think we probably as a committee would be very specific when we see that there is a need for that can't be handled as well as it might be if we provided that communication piece. So I think that that's well worth our considering.
And maybe what we can do as a subcommittee on the backup subcommittee that we have formed is for the next meeting, present that form notice so we can have it for consideration at the next meeting and take further comments on that.
Just like that, we could also do a notice for the knockout clause. Notice to the buyer who has the sale of other property addendum, where you give them the notice that we've received another contract. Do you waive the contingency or not? I know there's a Texas Realtor form for that too. And it's a very simple form.
Yes.
Non-controversial. So
Yes.
both of those forms would be good.
We'll borrow both.
I don't mind doing it. Just raising the question of.
Is that within our mission? Within our mission.
And
we do the notice of termination, buyer's notice of termination of contract, seller's
Yes.
notice of termination of contract.
Seller's notice. It completes a cycle. And I think for that reason, there's some validity to complete it. So we don't encourage agents to practice law by writing things they shouldn't. We provide them the form to utilize.
We'll have the withdrawal.
No kidding.
Let's think about, we'll have something presented at the next one. Let's have thought time on that. There in picking up on completing the cycle. I don't think it was in this comment. But we did have a deferred comment from last time, maybe elsewhere in these. But somewhere where there's a receipt of the additional option money added to the back of the contract addendum to the page 10 of our contracts. What we have now with the new backup addendum is the ability for what is effectively phased earnest and option money, where you pay one amount up front when you sign the contract with the backup addendum, and then a second amount when you go into first place after you receive notification the first contract's terminated. And that can be both for earnest and option. Currently, the contracts only have a receipt page for the additional earnest money. Because our contracts used to have contained for a while the ability to add additional earnest money. this additional option payment we added to the backup contract hasn't been there before. So we haven't had that receipt page. So I do think that's something we can add. And the discussion point, if I recall correctly last time, is do we put it in the contract? Do we put it in the addendum? But I think we need to add it. And for simplicity, maybe easiest to add just to the back of
That'd
the,
make it easier
put it all in one place.
because now usually on the first time you just say, I'm doing this much. And then I'm doing this much when I get into first place. And sometimes I put to be determined when I'm giving the extra money.
But isn't it only going to be used with a backup contract? So
For the option, yes. And
why not put it on that addendum? Because it's not going to be used other times.
and have it all together for the additional in earnest money and additional option, both on the back of the backup.
That's what I would do.
Or on the
But we
new
do
notice we
separate
create.
That's a good idea.
There's lots of reasons that there might be additional earnest money in a regular deal that doesn't have a backup.
Right.
Because it's gone on or whatever.
Mhm.
So
Brian
with-
just said, what about putting on the notice we create that has the receipt page? Because you are not paying it until you go in the first place. So is that a place that after you receive that notice that then you can add to it? I have never thought about that idea, but that's an interesting one. Diane?
Well, if we look at our page 11 now, looking to 1 to 4 family, we already have additional earnest money receipt. That's our receipt page. And space for additional option fee. If there's going to be additional earnest money and additional option fee, then rather than putting both of those on this backup addendum, why not just add additional option fee on page 11 on the receipt page if and when it's needed?
But my concern on that is, are we inviting
Yes.
agents, or at least putting in their heads the thought to write it in? Maybe write in phased earnest money in
Yeah.
or option money in a contract.
In a regular
as well. In just creating an opportunity for agents or inviting them to practice law.
No telling how agents would fill it in on either of the forms.
Well, they wouldn't be using the backup form unless they had a backup deal. So hopefully.
Well, yes.
About 99%.
But then we'd have to really add 2 boxes, would you not say? Otherwise, we're going to say, well, but we're doing both, so we need additional earnest money, we need additional option fees. So both need to be, I would say, together somewhere.
Melissa?
No. Disagree.
I don't feel like the agents are filling out that receipt page anyway. The title companies are. So if we added it there, I don't know that it would be giving an agent any ideas about what they should or shouldn't be doing, because they're not the ones that are accustomed to filling that page out.
Well, that's a good point, other than it's on the contract that they're going to be going over with their clients.
Yes.
Yeah, I just don't think they're going to read that deep into it. Realtors don't read already is a nice little quote that lots of folks use. And I think a lot of folks get to the signature line and then they go, and page 10 is just about who the agents are, and page 11 is just a receipt. You're going to get it later. And I don't think that they're spending enough. I don't think they're diving in so deep that it's going to become a problem if we did add it there.
What if we put a parenthetical saying backup only or something that limits its use, or if we did add it there, right? But
Well, okay, now I'm going to think about something else. So what if the option period is about to run and I'm the buyer, and through my fault, not the seller's fault, I've dicky-dooed around and I haven't had enough time to do my due diligence and I want more option time, I have to pay for that. Can't not pay for that. So that would be handy in that situation but wait, don't we?
It's on the amendment.
you had the
Yes,
amendment
but
for it.
that wouldn't say.
And the money goes to the seller on the amendment.
Go to the,
Yeah.
we had this
At the
discussion.
time that they request the additional time.
Yeah, and
Because
that
there's
raises
not like a 3
questions.
days or anything. Mhm.
Yeah, that may be a topic along with what you're thinking, SJ, that we talk about, because that extra money that is in the amendment to extend the time it goes to the seller, and then that has to be proven that the monies were paid to give to the title company. It may have been something that needs to be rethought. And so to your point, maybe that's one place we get rid of that and put it on the additional option money if indeed it's needed.
I'm retracting my comments after I'm looking at what we've done already. So it's on there enough.
And that language has paid has been a source of much debate at many meetings.
Yeah. It's coming with the document, so.
Right, and it's intended to, and so that's why we put has paid.
Right.
It's intended
So
that that's
get it
already been
done snappy.
Okay, so what if we take this back to the subcommittee and on these two particular issues for the backup contract, and then we'll present recommendations at the next meeting. Any further last comments on that before we go? Okay. So let's see. I think I'm on Stephen Ingalls wants a non-exclusive rep agreement. And supposedly, and hopefully this didn't really happen, that TXR told him to call Trek for the buyer's rep. But I don't think a lot of misunderstandings happen there. We as Trek do not promulgate buyer's reps in listing forms for reasons we've discussed at length here, and I don't think anything's changed from those prior discussions, which are publicly available at this time. So if we move to Scott Meyer's comment, wants a change to the short form buyer's rep. And I believe he has also a similar confusion on the difference between the broker lawyer committee and TXR, which Texas Realtors TXR has their own forum committees as well. You know, that's again trade association forums versus Trek promulgated forums, but they have their committees that work hard and draft forms for the association. Once that language added as well, that each broker may set their own fees added to the contract. Because we don't have broker to broker compensation or anything other than contributions, I don't think adding that would be appropriate in our contracts, that each brokers may set their own fees. That's a requirement under the NAR rules that are out there, but there's agreements, the buyer's rep and listing agreements that we don't do that it's, I think, more appropriate in. And anybody feel free to slow me down there if needed, but if not, I'll move on to Bobby Boyd. Wants Trek to add a release of earnest money contract. Provide a release of earnest money contract.
He wants to get
so similar to the TXR, Texas Realtors release.
We went down that route some years ago.
Yeah, we talked about that a couple of years ago.
Over my dead body, and
we decided not to do it.
Alive.
And this is one where the lawyers were pretty strong. And if we had a release form, the one that Texas Realtors provides is very broad. It releases the brokers, it releases the parties, releases the title company, it releases a lot of different people. And it's can be viewed in a way of putting a thumb on the scale, or taking some action, giving up some right from or the parties' rights on either side to pursue claims against some other parties. They may want to terminate the contract, but they may want to preserve their right to sue one of the parties or settlement providers that were involved in it. So we side the side of leaving those rights open and not dictating by a broad release of earnest money contract and release of everybody.
Right. I think he also is mixing some concepts here too. The second part of his comment, it says, since recently providing an option requirement for title company, I think he's saying, or maybe thinking, well, I should get the option money back since it's going to the title company too. But that's not the way option money works. Option money is spent. It's gone the minute it's paid because you're buying the option. So that would never be refunded in a normal situation. I'm not saying somebody might do that, but so yeah, for the record, I'm still against us coming up with a release for any earnest money, in case anybody thought I'd change my mind. And we wouldn't want to have a release of option money going back to the buyer because it always goes to the seller.
I concur as well on that sentiment. Lawrence Henry, let's see, we already see. Oh, do you know when we'll have the new survey affidavit to mirror the new T47.1 declaration? And the Texas Department of Insurance, TDI, has both the new affidavit and the new T47.1 declaration available for use. So that is out there now. This comment may have come in before those were officially released, but those are available. If you ever see that T form in the contract from 47, that T is TDI. That means it's a form that, like we promulgate for Trek, that TDI, I'm not sure if promulgate's the right word, but that TDI publishes, Texas Department of Insurance publishes through that agency. So then, let's see, is the next one
Pam,
21?
watch holds in mine. So I got them out of order.
Yep, I got it here. That's the supplement. So we have one. So for this is the letter. It's 2-page, starting on page 22. So
okay.
Here. I will start by saying I've read through this, and I think this is asking for specific legal advice that I don't think we can provide in this forum. And the broader issue that's raised here, I think, falls within a 1% category that is generally regarding an HOA mandatory fees that had different payments that were being made. One that was defunct that is arguably no longer required to be paid, but title companies are still collecting both fees at closing, and it's included in a certificate that's being collected when one may or may not be mandatory under the facts here. I haven't heard of that issue raised outside of this, and on this committee, unfortunately, we can't provide direct advice on particular situation. So I think that's the end of our materials there. Then we have the supplements that we can start on. And so there's a 5-page supplement that was added yesterday.
Yes, I've taken 2 of them so far. I did not take. I'm not taking them.
Okay, so then I'm going to walk through these. Pam Wachtholz, also that pronunciation, so I apologize in advance for butchering that name. Feels very strongly about the ambiguity of leaseback end dates. And this is similar to that paragraph 18 termination argument that we discussed earlier. And wants that to be clarified in specific. She brings up issues of like insurance policies that have coverage beginning and end dates that are clearly defined. But I think by necessity, how our leasebacks operate, we need that flexibility.
Yeah.
We can't list specific dates here.
We don't know the closing's going to happen really until it happens.
And so, the one thing with paragraph 9 of our contract, it says closing will happen on or before a certain date. Or there's certain circumstances that closing by the contract can be pushed back, like for paragraph 60 objections that can push closing to 7 days after those are cured or waived. So it really prevents us from saying, here's the definite end date in that particular situation.
But I think she's talking about the lease back. She's just talking about the 90-day lease back.
Oh, on the sell side here.
Yeah, she's talking about the 90-day lease back,
Well, let's look on.
right? And that she of the lease back and end date.
I don't have my notes.
Are we talking about the seller's temporary residential lease?
That's what she's talking about. That's how I would read that.
Okay, so let's look at that separately.
Well, it does have a specific date on the seller temporary residential lease. Now that does itself create a problem, because what happens if they amend the contract to extend the closing date, but they forget to amend the seller's temporary residential lease?
It's a problem.
They need to remember that, but
Yeah, it does have a blank, which you could say in 20 days, or you could say.
And I think that's what they usually do.
29.
They put days, don't they, guys? They put days rather than
put either one.
A date.
You
And the
could
lease
put,
back?
3 days after closing.
Usually like 3 days. Yeah, it's usually
It
days.
doesn't say.
Diane, you have your hand up?
Yes, the time period, she brought up an interesting point that I think maybe we should give some thought to as far as the contract in paragraph 9 as well. And here's the issue that comes up often, that you've got a closing and the buyers have the moving van ready to move in, and the closing date is Friday, January the 10th. We just closed. Whose day is that? And should that seller have already been out? And so I hear different answers to that question. I called the legal hotline and they said 12 o'clock, on 11:59 on January the 10th, the seller has, and the buyer doesn't have possession yet. And so it happens not all the time, but it does happen. And maybe there is a definition by putting times in there that would be helpful to avoid that in the closing as well as leasebacks. Just a thought. What do you think? Is that an issue?
So I'm pulling up. Welcome
feel like
thoughts. So we have another hand up.
Doesn't the contract speak to that? Isn't that closed and funded? I mean, was it absolutely funded at that time too?
Yes. Yes. So
Yeah,
you're
so if you
closed and you're funded. Therefore, right now it is 1:45. We just closed and funded, and I'm the buyer. That means I can take possession.
Yeah,
Yeah,
contractually.
that's true. That's true. Yeah.
Once that money, once you've got confirmation the money's sent and you've
Yes.
exchanged the deed, and I know because I had a trial in Houston that went on for 3 weeks where this was a jury, y'all know what I mean, jury charge submitted to the jury. Once it's been funded and you've get paid, signed off on that deed, whether it's 11:59 at lunch, 2:30 in the afternoon, it is
Yep.
now that other person's house. Get
Yep,
out.
I agree. I agree. Yes, thank you for that clarity.
Christy, your hand's up next.
So I'm going to say that from the perspective of what we see day to day, I think this bears some continued conversation, simply because what we're seeing is close dates do change. Agents don't think about this, or close dates change and then the other party's no longer willing, even if we do think about it, they're no longer willing to extend out the lease back date. So what we're seeing is a large number of agents put 5th day after at 5 p.m. because there is ambiguity around when people are interpreting when move out is. So they're writing it in there. And I'm not saying that, that they may be solving their own problem, but we're seeing 3rd day after at 5 p.m. or 10 p.m. To make sure that even if the close date changes, that date shifts and automatically protects the seller with that seller's lease back. So I do see some agents thinking about it. That may be the problem solver in itself on them just putting it in that way. But we do see this, and there is a lot of ambiguity around the actual time of move out and a lot of discussion around it that I think leads to more conversation.
I mean, that makes sense, but if your agents are starting to put in contingencies like if then or if after so-and-so, then they're writing in an unauthorized practice of law provision. And then they might be getting that right. If after 5 or 5 p.m. Central Standard Time, is any time after 5 okay? But basically now they're writing in a law provision. So it makes sense, Christy, that you might want some more clarification in this.
And I'll briefly, after the comments made, get on my little soapbox on paragraph 9. But we'll go to Melissa, Mary, and then Brian. Melissa.
Okay, so yeah, I have always instructed folks not to write in 3 days or 4 days or however many days. I've instructed them to say it terminates on January 10th. And January 10th goes until 11:59 p.m., just like everything else in our contract, unless it's specified, which is the 5 p.m. deadline that we have, right? There's one place in the contract. Everywhere else, it's 11:59 p.m. And so if they just put a date in there instead of wishy-washy the whole 3 days later. Now, I think Brian mentioned it a minute ago, it becomes a problem when closing dates get moved, because then you've got to do the amendment to extend the closing date and change the date of the lease back. And to Christy's point, sometimes the sellers are like, no, bummer that it's moving. I can't move out until this date, or I'm moving on this day or whatever. And then we're renegotiating that lease back because there's a drama with the actual closing date. But if they just put a date in that blank, I think it solves the issue.
Which may be necessary evil to negotiate the lease back in those situations because the close date has changed and circumstances have changed. Neither party can still stay to the original closing date with the same expectation, but so it may just, in my view, in a lot of those cases, you would renegotiate that anyways. And that would solve some of that. But Mary,
I mean, I know about this case and they literally stayed until 11:59 that night, and it was a Friday night, and it created a little bit of a havoc. So I think that's why she's asking, can we actually put a time in there so that everybody's prepared? Because they did. They had their moving van ready to move in, and it sat on the street. And the movers had charged extra money waiting to move their furniture in. So that's what I think where this all came about.
and so
Or you just set up the moving for Saturday, but you have to let people, they used every minute.
and that can be done with the lease as it is now, right? You can say X date at 5 p.m. in that blank. If that was a concern there, which is a little different from our closing and funding, which is the open-ended possession from the by the buyer if it's straight out of there. But if you're in the lease document itself, I think it allows for that practice. Brian?
I don't know that we need to do anything, but I think we could add value if we said it terminates blank AM or PM on, and then check the box, blank date, or the blank date following the date of closing and funding. Give the people the option to fill it out. And, I've seen that. The moving trucks here. What do you mean you're not out? And they said, well, we have till 11:59. Let's avoid that. Say 5 p.m. or noon or whatever.
That's an interesting idea for clarity. Yeah.
Spending a lot of time on something that is.
Is this 5% or I mean, I don't know.
It's at least 10%.
I've seen it. The thing I've seen the biggest issue on is when they extend the closing date, but they forget to extend the date that the lease terminates.
So we're going to try to change all this up because they didn't get it right the first time on the forms. And so we're going to give them something else to fill out that they can't get right. I mean, come on. I mean, at what point do we have to say, y'all got to be able to figure this out?
That's what I'm saying.
Thank you.
Well, I have to say 2024 was a lot of change, y'all. It was the year of change. There was forms coming and forms going and new forms and this and that. It was a lot. It'd be really nice to have a little bit of 2025 without a lot of extra changes. That's all I'm saying.
That's not the way it works. And the legislature's in session. So wait till the next meeting.
I know.
Isn't even
just when it's not a necessity, kind of like this. Whew, for later.
So maybe we keep that in the bucket for consideration. And if we go forward, let's see, if more come in on that. Going forward to Dan Covington, I believe I'm reading this here again. I believe we've addressed all these compensation concerns that are raised. If we ask, let me know if he wants idiot proofing, which would be great if we can do that to the extent we can. Let's see, Lacey Pipes. Let's see, addition here. Request assistant can give in. So that points to the ABOR form, that the unlock MLS form that we discussed earlier, and she actually attaches a copy of it. So this is that form we went over earlier. That's a potential addition to the contract. Michael, is it Thero? I'm looking for clarification. Change made 1 to 4 by placing an amount either blank. Would I be obligating a buyer to pay buyer's agent compensation, or does it obligate seller to pay buyer's agent commission? And so we've been over this several times as well. If you're putting an amount in 12A1B, you're obligating the seller to pay that amount for buyer agent compensation. Sandra Hines, concerning 1 to 4, there's disagreeing brokers on how 12A1B should be filled out. Should 12A1B be filled out with the amount that's in 5A1 of Form 2402 compensation agreement between brokers, or is that because it's on the CABB that you put 0 in 12A1B? Again, two different amounts. That's broker to broker from 2402 doesn't go in paragraph 12. We have Todd, commission shared. I think that's all the.
But you still see there's a lot of confusion.
There's a lot of confusion that's highlighted by this for sure.
They've only had it a few days.
Clarification on 12. Say set a buyer paying a dollar amount. Please clarify. Seller's broker agreed to pay the buyer's agent. Need response ASAP. So this is a similar thing that we've already gone over about what the blanks mean and who pays what. Robin Harris. Robin's still here. Do you want to take your comment that you submitted here? And this is the I think the farm and ranch issue that we started touching on earlier. Is that?
That's right. Yes.
And so,
Would you like me to?
Yes.
Yes, that'd be great if you can
So
expand on that.
background, we've been trying to write an article explaining some of these changes to put out to everyone. And this farm and ranch issue is just through it and about it and around it, and just could not come up with a clear way to explain it easily and or even how to explain it. And it may just be simple. We may just be overthinking it since we've been living in all of these changes for so long. And so thought that maybe some new eyes or what the intent was on that paragraph 12 change, how it relates to this, because this farm and ranch contract is the only place where there's the confusion. And maybe it's not confusion, and if so, then please let us know and we'll just let our members know.
And so the specific issue addressed and is filled out here, if an amount's put in paragraph 12 and also on this farm and ranch language at the end that the seller is going to pay an additional fee, there, what controls, and or do they stack upon on each other? And you know that is, I think, an issue that's not abundantly clear in here. I would, before I open my mouth and stick my foot in it, I'm going to recenter my thoughts on this. But
I'll stick my foot in my mouth. How about that? I think that however you get to it, it's hard to do it without knowing the specifics of the transaction. So I would say, if you're looking for a black and white answer that's going to apply across the board, the only one that you can give out there is that if you use the concession out there, I would hesitate on using anything on page 10, because chances are your seller's agent is going to have a listing agreement, and hopefully they will. So that takes care of the listing agent's fee. If you use the concession, right, then you can go ahead and pay that full amount. Hopefully it's the full amount. Then you shouldn't really touch page 10. If it's something less, then you got to make sure that balances out correctly. So you're probably already saying that, right? Is what you're already saying. But I think that's the only global answer you can give. Otherwise, you have to get into the specifics of each transaction.
And
They do stack.
the way that we did address it is be aware that this language may create a discrepancy, so be careful. And that, we were just very, very broad without getting into any specific examples or anything like I've provided here. So,
Well, I mean, the danger about the discrepancy, like Rhonda said, it's the terms of the deal. I mean, and there could very well be a deal where you do stack, and stack multiple, there may be multiple payments going.
I look at it a different way, though. If I can throw in something, is this a separate agreement or part of the contract, right? We have it below the signature line, they sign again. And if this was outside the contract, if this was in a 24 or in the buyer's rep agreement, there's no question that paragraph 12 would be a contribution towards the amount the buyer's agreed to pay.
Right.
But because this is included in the contract itself, is this, somehow then not considered separate? And it is a payment that aligns with the seller paying this percent to the buyer's agent and buyer paying this percentage. And the confusion, because we don't have language to the contrary, is that if it's outside of it, no problem at all. But by being within the same document without language to highlight that, am I hitting that?
No, that's what you're saying.
And so is there a way we can address that? Because I don't think we've necessarily focused and centered on that confusion.
The way to address it in that case is to avoid the stacking altogether and to use one or the other, but not both. And that may mean that you have to change your listing agreement.
And if you use this on page 10, it's broader than just the buyer agreeing to pay. So it's not, we can't necessarily say just use paragraph 12 and not this, but down to the whole thing.
I wouldn't mix the two. I don't think I'd mix the two. I'd go one or the other and then I'd change my listing.
Well, and then there's always, again, our very first idea that we scrapped that has sort of rearisen here and having a separate agreement. And they can
But
always use their-
I think this, in the farm and ranch, we have too much in there. And we have the ratification of fee, we have the separate agreement, and then we have.
There's a lot. And Robin, so you've been getting complaints from?
No,
No, you just are.
we've not been getting complaints. We understand farm and ranch brokers are different. And that's why this language is in here. There are a lot more sophisticated transactions and parties that are going on in there. We've just been trying to explain how the changes impact compensation and the different forms and how they all interact. And this is something that we're not able to explain.
My feedback that I've received for the most part is that I don't want to say business as usual, NAR, DOJ. It is not business as usual, but that the brokers are negotiating with their selling clients, a listing agreement that includes payment of buyer compensation or, if it buyer's broker compensation or they're not, it's one or the other and then the whole thing is up for negotiation. But I haven't heard of any of the brokers having a problem yet.
So this last provision down in page 10 was, I think, originally placed in there because the buyer's agent and sometimes even seller's agents didn't have written agreements.
Correct.
Right. So if that's the case where both of the agents don't have agreements, then you could use this provision and not deal with the concessions. If there is a listing agent that has a listing agreement in play, then I think you use the concession or this, but don't use both.
Which makes sense.
Right.
One of the other issues is why it's overthinking, I think, is farm and ranch properties, the NAR settlement agreement doesn't apply to farm and ranch necessarily.
Not necessarily. Yeah.
So having that buyer's representation agreement from the very beginning, MLS rules may require it, but not necessarily every single one.
Yeah.
So
And
just another level of nuance on the issue that we were trying to think through.
And I would argue this needs to be considered just like a separate buyer's representation agreement. And we lead in the sentence, one is below the signature line. And it states upon closing of the sale by seller to buyer of the property described in the contract to which this fee agreement is attached, separating it from the contract itself. It's being attached to the contract, just like you would attach a buyer's rep outside that at some other payment. And so my mind and initially considering this is you have to treat it just like it was an outside buyer's rep for purposes of the contribution if they both happen to be filled out, which may end up unintentionally
easily
or a mistake being made. But that's how I would look at this situation. We're trying to, piece it apart to do that.
So
Pretend that it has a dotted line right above it and we can just tear it off as a
there we
separate.
go.
And that's a,
Right,
that's
it
a good
just
way
comes
to,
out. Yeah.
that's where I'm leading to where, how that operates with how that is. It's below signature line. It says it's attached to the contract, which doesn't mean it means it's not part of the contract itself.
So I'm gonna give the story, since y'all have all done a rabbit trail, I'm gonna do mine. On the calls that I got from the brokers that actually brought this in was where a buyer did not have a broker, said they did not have a broker, viewed a property, and then had a broker try to submit a contract. And no, you're not procuring, and the seller's broker is like, I'm not paying you if, I mean, you could submit whatever you want. So then the contract came in, with the seller paying the buyer's broker instead of the seller's broker paying the buyer's broker. Anyway, it just turned out to be one of those situations where it was
Well, I think Robin's
bad
going to
business
give a
acting.
very clear, concise.
Yeah, we're gonna do it.
We're
We're
going
gonna
to
do it
push
clear.
around everywhere.
And I hate to push back, but.
Push.
I
Push, do it.
And I'm not pushing, but just, so I did include, would it be 1%, the either or option, and I understand, well, they shouldn't be doing both. But if they do, it's 1 + 1 is the consensus.
Right.
Do your math.
And are you on the last comment you had?
Yes.
Because the other thing here is if you look at the last comment, it also says if the buyer's paying it, do you put it in 10? And that's not what the conversation has been. The conversation has been, if we do a 2402, which the seller is brokerage and brokerage have agreed, we're putting it on 10.
Well, 10.
And here's something that, I'm just saying, time
Farm and
could
Ranch.
really be screwed up.
This is Farm and Ranch, which is separate from that page 10 discussion.
What do you want,
earlier.
Robin? I mean, since you're pushing, what exactly do you
Well,
want? Tell us if we could do
Time
it.
machine, would that be?
Yeah.
Time machine? Yeah,
I
okay.
don't have that.
Go back and redo
What
it.
can we do?
That's something to think of,
If we want
President.
to.
Well, I and the association, we don't want any, other than to be able to easily address the question when we get it. Or maybe not easily, but to address it, so that it sounds like we can give some guidance moving forward. And, having taken those, we have those words and we can take that now and use that as far as realistically, you should be doing one or the other. And if not, then you're stacking or you're going to be responsible for both.
Make sure you do the math right if you are trying to mix.
And I would qualify that by a court can tell us we're wrong, right? And we're looking at this as committee or individual opinions on things that I read this as it's a separate agreement that's attached to the contract. You view that the same way as you ripped it off and had it in a separate buyer's rep, which then would provide that contribution towards that amount that was agreed to.
But I'll tell you, your title company's not going to be closing the deal until you get it right and everyone's on the same page.
Everyone's going to be on the same page at the end of the day, but so is that as helpful as we can get?
Thank you. Absolutely.
Okay. And that's something that we'll put on our list to clarify as we're looking at this whole language up there and adding something in there. I think we'll bring to the next meeting because of that. It is 1%, but it's in our language. I think that is worthy of looking at. How do we clarify it to, if that's our intent, make it clear to those that read it. Okay, so then we had another supplement, I believe, this morning.
Supplement?
Let me see if I can pull that one up. Was that Lawrence Henry's?
Yeah,
comments?
Lawrence again. Lawrence is busy.
Okay. So his first comment, the updated addendum for backup contract bifurcates the option fee with the addition of the new additional option fee. The way I read this revision is it still requires both original option fee and the additional option fee to terminate under the option period rather than creating two separate option periods. Is that your understanding? Real estate agents are interpreting the additional option fee as not being required if the contract is terminated prior to the additional option fee being due. And I'm guessing as being the intent for the form change. But paragraph 5 of the contract states that the option fee is not delivered when you do not have an option period. And so you'd love to know our thoughts on this. He's concerned because it's not a separate defined term, the additional option fee. I believe the intent and how our contracts work there is when you pay the option fee up front, right? That's the option fee defined in the contract. That's when you gain that option to terminate. It has to be paid timely. If you don't pay timely, you don't have the option. If we go to our backup contract, right now, that's a separate payment that doesn't have to be paid until a later date, and is distinct from the original option fee. But I want to look at this in specific regards to his concern about a lack of a definition. I haven't seen a concern about this in my reading of it prior to it. So we're in A, and we're in the backup addendum now on A2. Buyer shall deliver additional earnest money of blank and an additional option fee of blank to escrow agent within so many days after the minute effective date of the backup contract defined below. And then in E, we come to E, the next one that's applicable, failure to timely deliver additional, F, failure to timely deliver additional option fee. If buyer fails to deliver any required additional option fee within the time required, buyer shall not have the unrestricted right to terminate this contract as provided in paragraph 5B of the contract. And so looking at that, my initial reaction to point him to is that it wouldn't be within a time period required. You're not required to pay that additional option fee until this later date, right? So it's not included. You don't need to have that to have a valid option at the time you pay the original fee. So you still have that option. And if you ended up exercising that option, that time period never came into being. You never had that trigger to pay the additional fee, so you wouldn't have to pay it just to terminate the contract.
So you can get out at any time before you're moved into first position. But once this is triggered, you're moving into first position, and we're going to have in here when you have to do it.
Correct.
You're going to have within 3 days, let's say, 3 days of the amended effective date, you have to pay your additional option fee. And per F, if you don't, within 3 days, then you don't have the option fee.
Correct.
And
I guess I don't understand the issue because if you don't pay the option fee within the either one of the option fees within the required time, you don't have an option.
I mean, his question is,
you have to pay both to be able to terminate.
Requires both the original option fee and the additional option fee to terminate, and the answer is yes.
Because you're not going to get to the amended effective date if this never kicks in.
Yeah. So well, it's no, because you don't necessarily have to pay both if you
Right,
terminate.
if you terminate the first one.
Right.
But if you want to terminate in the second one, you have to have
Yeah, because
done everything in phase one and then everything in.
Right.
Well,
Because if you never
phase one
get to
and
the
then
amended effective date, then there's never a duty to pay the second fee.
Right. And it's blurred.
The contract's terminated.
Right.
Right.
Yep. I'm not seeing the confusion created by the, I'd see the confusion he has, but not that our language actually lends itself to that issue. That would need to be revised. In adding a definition of the additional option period, I'm not sure something that would solve.
I don't think so. Do you mind going back to the form real quick?
Sure.
What does E say?
He's asking to put a definition of additional
Yes, option fee.
option fee.
Fee or period? Let's see.
Period.
Oh, yeah, period, but.
I think he
Well,
means
that's up.
fee. So we have, it's this and F. I think legally we're covered. It's just a matter of whether clarity needs to be provided to address it. Does anybody online feel any need to add any additional language?
No.
No.
How do we know how much, how do we know what the additional option period is? We have to go back to the original contract?
No, because it changes to the amended effective date.
Yes, but this says paid within, but it doesn't say how many days it is. So it's back in the original contract. I actually am understanding his concern now.
Yeah, no, that's what I understood, is that if they became primary, then they got the number of days that they requested originally in the 1 to 4 family. They requested 5 days or 7 days or 10 days. The new starting date is your amended effective date.
Okay.
That's also the new, it's just like we executed a brand new contract. You got 3 days to turn it in and the clock is started.
Okay, Ron is directing us to J. If buyer has the unrestricted right to terminate the backup contract, the time for giving notice of termination begins on the effective date of the backup contracts, continuing after the amended effective date, and ends on the expiration of the buyer's unrestricted right to terminate the backup contract, which that didn't really answer either, but
Well, no, that basically says that you've restarted.
yeah, it does. It's not the most crystal clear, but
That was existing language in the backup contract.
Yep.
Yeah, and that's how it's been. I mean, it's been
Practiced.
done that way in the field for forever.
It's the last sentence of H. For purposes of performance, the effective date of the backup contract changes to the date buyer receives notice of termination of the first contract.
Well, I propose, because we're sending this form back to the subcommittee, that we initially look at this language to see maybe if a clarification can be made on that issue, or just take a more detailed dive into it, since this was a late comment coming in today, and address it that way.
I mean, that's really one of the things we talked about doing anyway, was systematically giving everybody a good scrub at some point.
Yes. And I think that's it for the supplement.
The one that you touched on briefly, the notice of termination
From the condo.
no, for the condo.
And which one was that?
That was right after Lawrence Henry's backup contract.
About having the right to the notice of termination, talk about condo docs.
Yeah, it's still.
Still on the second one. Okay, so Lawrence Henry's side comment there is there a reason Trek doesn't include the ability to terminate the condo contract because of the post-contract execution delivery of condo docs and resale certificate per the property code? The property code provides a termination right in the what's it, chapter 62, I believe, 82, of a right to terminate the contract, and this is a statutory right, if you don't receive these documents before executing the contract. And it's actually with the time period after the date you actually received them. It's a similar termination rights under the mandatory HOA addendum, and that's on the termination form, but not for the condos. I don't know if there's a good reason that we don't have it.
It's there. Number 8, other.
Yeah, that's what I
Fill
was
it
going to
in.
say, is we would just write it in under other.
Are we looking at
And
that?
I'm not sure that you'll hit your 5% rule on this either, just saying.
The termination?
That's the one that you just recommended for adoption.
Yeah, but after that, are we going to be looking at the form for anything else?
Unless there's a legislative change that would.
I agree generally with Brian's comment that other, and if we do have reason to revisit the form, I actually ran into this issue now in terms of the form of notification, but the termination right, whether it's at play or not, in 2 matters here recently. So but before that, I can't recall the last time that I've had that issue raised to me. So I'm not sure we need to cloud or add additional language to our contracts unless maybe if anybody else has seen this more often.
I mean, hey, we could say, why don't you have something for a casualty? Right? There's a termination right there. So or default.
I think Ron is noodling on whether we want to, are you noodling on whether we want to?
No, I'm just.
Or we actually,
No. I was asking the question if we were going to be looking at the termination notice again, but we're just.
right, but do you want to hold back?
No.
We need that.
Okay.
Okay, well, let's keep that in the bucket and see if that pops up more in the future. So I think that's the end of agenda item number 8. Next one is agenda item number 9, discussion of possible action regarding recent court cases. And we actually have a really good case today. It's not often we get cases that specifically deal with our contracts. And this case, which is the Hammond versus, not sure the exact party, that's the one. Hanser. A lot of different parties. This is out of the Court of Appeals, First District Court of Appeals, which is in Houston. And it's a recent case from October 31st, 2024 with a site or a case number 01-22-00707-CV. This involved alleged misrepresentations and failure to disclose defects. And specifically, the big issues were water related issues with stucco. And the court really dove into the as-is clause language. It dove into our seller's disclosure. It dove into a lot of different language in there. And it was a situation where the buyers had alleged the seller knew about or should have disclosed because of all these different outside factors that didn't necessarily tie in direct knowledge of the seller. In particular, with the as-is clause, one thing with as-is doesn't necessarily mean as-is. Courts look at is it boilerplate language? Is it something that the parties negotiated back and forth and determining whether they're going to truly hold it as is, meaning you buy it and with all defects. In this case, the court noted that our forms have an election to either do as is or as is with certain repairs. And because of that choice, it moved it to the side of being in a negotiated term, which made it more enforceable. And then it looked at the seller's disclosure notice and the terms that are written in there about it being a disclosure of the information the seller knows, right? And that the seller doesn't have to do a further investigation to go look at different items, how the broker didn't need to go and do a further investigation of the property to find issues. And in this particular one, there wasn't sufficient evidence to show that the seller had lied and that there was no sufficient evidence to show the seller actually knew of the problems. But it has a lot of great language. It's a long case, but I highly recommend reading it because there's a lot of good little points on various different issues, like do repair issues that have been repaired, do those have to be disclosed, right? And there, if it's been repaired, I would say by a reputable person that you have no reason to believe it wasn't done incorrectly, then that's no longer a current defect. And so it wouldn't necessarily have to be disclosed. I would caution that if you use Joe Blow across the street, paid him with a 6-pack to come fix something, that decision could be different. So this is still legal in nature and walking the line, but it's a very instructive case.
And which, on that one note, on the who to repair, we have since amended the contract to make sure that it's by a person licensed, or if there is no license needed, that it's a person who regularly performs.
And this was one that I think was done before too. They, painting company or something that came out to do things. So it wasn't necessarily in the contract negotiated, but prior issues that were repaired. A big caution there for those listening on this and if something is a previous condition on the seller's disclosure, it doesn't matter if it's been repaired or not. It says previous.
Yeah.
So don't let that analysis cloud you to say, oh, I don't have to disclose prior, was it wood rot or
water penetration?
There's these certain things that they say prior, it doesn't matter if it's been fixed. So But this is very instructive on a lot of different issues centering around our contract, the seller's disclosure, and broker liability. So I would highly recommend a read.
Yeah, I would say, also, as the author of the last treatise on broker cases, suing broker cases, and this is almost a culmination of my entire law career. I mean, this is Dick Hargis's and Grant Harpold's and me and Allison Johansson's cases. We tried most of these cases throughout, and this is a wonderful job by a court to put it all together. And irony of ironies, Justice Richard Hightower is now off the court. But it's a beautiful opinion, and I'm delighted that it's out there. And I hope all the other.
And it has drama in it too.
It does. There's some drama. There's a little drama.
Yeah, the sellers, sellers got married later. It's all kinds of.
They
were going together.
And speaking of, you do have that great treatise on some of these issues. Where can everybody find that? I have it saved on my system.
It's on the Swanson PLLC's website, but it is 10 years old, and I'm determined to update it. And I was holding for this, so I guess I have to do it. We'll circle back after the first of the year is coming back to roost.
It's a great read too that goes through a lot of these cases and a lot of other issues as well.
Like us, read this. It's beautiful. Way to go, Justice Hightower and friends.
So any more comments on the cases or any new ones anybody else would like to bring up? Okay, so our next meeting. Oh, Melissa, I see that. Melissa, go ahead.
Sorry, I just had two things that a couple of students in classes have asked me to bring up, and I don't know that either one of them are things we can solve, but that were things that they just wanted to make sure that we were aware of. The first one was I had some folks asking specifically about drilling for lithium. And is that definitely included under the geothermal, which we've added? I don't know if we want to give any clarity to that or not. And then the other thing that was specifically brought up was specific to an MLS. And when you close out your transaction as a real estate professional, you go into the MLS and you say who the other agent was and the sales price, and you put in seller concessions. And the question was, does that include 12A, 1B, and 1C? And so I just think it's important for, while we don't control the MLSs, it's important for us to note that there are some other additional parties, because we talk about, Texas Realtors a lot and about how Trek operates, but the MLSs being separate, I think is just another thing for us to consider with regards to the compensation.
On the lithium issue, I think that's a natural resource. I'm not sure it's geothermal in nature, but it would be considered a natural resource, which is be one of the leases that's required to be provided. So I think it generally falls in that same bucket. And then on the duly noted on the second point, how it's being described in various different forms by different parties, it's can lead to confusion.
I guess each MLS.
And there, I would say clearly in our contract, B and C are added on each other, and how the offers presented, taking into account the total amount of concessions that the seller is willing to consider, can be done in the contract and totaled up to equal it or include it all in one or the other category. Potential confusion is definitely duly noted. Next meetings. So are we thinking, let me ask that real quick. Are we thinking July meeting, right? Because that's
the July meeting is the last official meeting for those of us rolling off. Yeah, July 19th.
Okay, so we're looking at two meetings coming up. We have a June meeting and a July meeting that we scheduled. And that's to account for any potential special session that may come after the end of the regular session there. So with that, we've already talked about the date. To celebrate our members that are rolling off, we will have a little get together that we'll circulate here to have a great send off and appreciation of everything.
With no business conducted.
No business conducted, open meetings, and that'd be probably welcome for many of us to actually have that with
That'll be
us.
the July meeting, right?
July.
That'd be the July. Let's see, do we have the July meeting as a temporary one? So if we don't have a special session that we will.
So the one.
You have it on the calendar.
The one thing about that is that if there are more complicated bills passed that might require a couple looks or passes at, I think in the past we've had that June meeting to kind of do a draft and then a July.
Okay.
Right.
Okay, so we're good there on the
think so,
time then.
yeah.
Okay, so those will be firm meetings. And then I think we're good. So do we want to look at the minutes now, circulate those
Later
later?
and do that. It's up to you.
Let's look at them now. Let's, we approve these real quick.
That's
knock them
awesome.
out.
Let's see here. If I do this correctly.
Were there any future agenda items that we were keeping in our rack from last time?
So our deferred
That you-
comments, I think we went.
That we need to talk about at all?
We had the receipt page for the additional option money. We had the broker responsibility recommendations. That,
So Lee didn't show up, right?
in language to add to 6C1 and 2 were the deferred that I had listed to go. I don't feel a need to.
Okay.
You got moved up.
Oh, well, all the sunset issues. I mean, they're all going, all of those have been sent out to
I'll work
the
with you later on.
committees,
For discussion next time.
right, for discussion. So they're gonna pop back up.
Hey, can you
So-
go back up, Ron, just a moment? Go back up to the names.
Easier said than done. Hang on a second.
So sorry. I think there's a T missing in Commissioner Hartgrave's last name.
Okay. Thank you. I'm not even sure he was there. I'll get with, but thank you. Oh, he was not here?
And Erica's with a K instead of a C.
Okay. I'll get,
Right, the Avenue line.
EY?
EY, yeah.
And Erica with the C.
Okay.
Kirsten Crawford.
So I'll put those in.
Okay.
I've got their names here. I'll put them in after we.
Get the guts.
Yeah.
These is easier.
This should be 4.
Where do you move down?
Move up? Okay, just let me jump up.
So the IABS and the notice of buyer's termination of contract will move forward for the February truck meeting.
Yes.
Would we anticipate availability March, or do you have any idea what the likely date's going to be?
We haven't talked about that yet, but I think that's typical. Although with the IBS, sometimes we give a little bit more time with that since it is a heavier lift. And so I think in the past with that, that's been like an April 1st date. But we haven't quite discussed that yet.
Thank you.
You already go down the next page?
Yes.
On A, are we gonna leave it at 662.021?
We decided for now, and then we'll come back when we get the drafts and discuss that issue further.
Right.
Yeah, thank you.
For F, are we deferring or do we decide to take no action on F regarding the condo?
Um,
No action.
no action? Okay.
Yeah.
Looks good. Any further revisions online?
Looks good.
I think it's good.
The names.
Sounds good. Okay, so
Thank
we
you, Ron.
need with the added addition of the names on our handwritten list here, approval of the minutes, say aye.
Aye.
Against?
Aye.
Nope. All right, minutes approved. Thank you, everybody, for everybody had a smooth trip up here and a smooth trip back, and appreciate your time as always. And
Hook 'em horns.
let's go. Yeah, we got plenty of time, hopefully, to make it back for the game here. Hopefully, everybody can get behind Texas, no matter what team you're actually.
Who are they playing?
Oh, SJ.
Oh man.
That's embarrassing.
Ohio Junior College.
Sisters of the Poor.
On that note, we'll officially adjourn the meeting. Thank you, everybody.
Bye, everybody.
Aye.
Thank you. Stay healthy.